afternoon. We'll call to order the regular meeting of the City of Murfreesboro Board of Zoning Appeals for October 26, 2011. The first item on our agenda is the consideration of minutes for our regular meeting on September 28, 2011. Those minutes were included with our agenda materials. Is there any change to those minutes? If not, those minutes will stand approved as presented. And we will move on to consider new business. Our first item there is a weeds and grass exemption request. It is application W11056 by Mr. Jim Wood for the Saratoga Park Homeowners Association. He is requesting a partial exemption from the weeds and grass ordinance on property located south and west of the Forest Point and Saratoga Park subdivisions. It is requested that a portion of the property return to a natural state or as a wilderness area. Mr. Blomley, if you would review that application for us, please.
Yes, sir. Thank you, Chairman Rogers, and good afternoon, Chairman Rogers and members of the board. As you mentioned, the first item is for a partial exemption from the weeds and grass ordinance. We discussed this at some length. Not this particular application, but the new procedure that we have in place for the weeds and grass exemption at our last meeting. As I mentioned, the board will recall that at the July and September regular meetings, the planning and legal staffs informed the board of an ordinance that was passed earlier this summer pertaining to exemption requests from City Code Section 14-53, also known as the Weeds and Grass Ordinance. The legal department prepared a memo prior to the September meeting summarizing the new ordinance and the process for requesting an exemption. This memo has been included in the agenda materials this month as well for the board's reference. The subject property before you today is a part of Tax Map 102, Parcel 48.01. If we can pull up the aerial photograph. It is a part of the Saratoga Park Homeowners Association property, which stretches all the way from here, this is the southeast corner of the property where they have their tennis courts and swimming pool and pool house and the walking trail that runs along the south side of Lytle Creek back over to those amenities. The common area is also on the opposite side of Lytle Creek, bordering the Forest Point subdivision. Forest Point the Forest Point subdivision is accessed by Middle Tennessee Boulevard, and the Saratoga Park subdivision is accessed off of Southeast Broad Street. So Saratoga Park goes as far west as the end of this cul-de-sac right here, and west of that property line is Forest Point. The subject property is owned by the Saratoga Park Homeowners Association and is a part of the common area of the Saratoga Park subdivision. The Saratoga Park subdivision is located west of Southeast Broad Street and south of Middle Tennessee Boulevard. Access into the subdivision is via Southeast Broad Street. According to the applicant, the total area of the parcel in question is 22 acres. However, the applicant is seeking an exemption on an approximately 10-acre portion of the parcel. The portion of the property that is not a part of this request for exemption is the portion south of Lytle Creek and the portion adjacent to the residential lots in Saratoga Park. As I mentioned, it houses the various amenities used by the Saratoga Park residents, including tennis courts, a swimming pool, and a walking trail. The portion of the property that is being requested for exemption is along the north side of Lytle Creek and is more remote from the portion of the common area with the amenities. The approximately 10-acre area being requested is directly adjacent to the neighboring Forest Point subdivision. It abuts lots on Forest Point Drive, Boone Court, and Nathan Court. The applicant is requesting that this 10-acre area be allowed to return to a natural state or a wilderness area. And now what I'll show you is the exhibit that the applicant prepared in his request. The hatched area is the area that the Saratoga Park Homeowners Association has requested for exemption. And as I mentioned, this line here, which is in between the two subdivisions, if you follow that straight down to Lytle Creek, is the beginning of the exempted, or the area that's requested to be exempted. And if you follow that common area, the hatched area, along the north side of Lytle Creek, south, and west of the Forest Point subdivision, all the way to the northwest corner of that property. That is the 10-acre portion that is being requested for exemption. Included with the agenda materials is the letter from the applicant outlining his request and the reasons for his request. Staff has also included for the board's reference the correspondence that has been received from neighboring property owners objecting to the request. After a presentation by the applicant, the board needs to hold a public hearing on this matter and then determine whether or not to grant the exemption request. Mr. Wood and Mr. Rick Cantrell, both representing the Saratoga Park Homeowners Association, will be in attendance at the meeting to answer any questions that the board may have. And it's my understanding that Mr. Cantrell will be presenting on behalf of the board. In addition, members of the planning, engineering, building and codes, legal, and fire department staffs will also be available if you have any questions for them. Now I'll just show you some photographs of the area. And this is the area that is being requested for exemption, which would be south of the homes in Forest Point and north of Lytle Creek. And these are moving from the eastern part of the request area to the west. This is very similar to the route that we followed on Monday morning on our tour of the property. This is looking down at Lytle Creek. And in the background of this photograph, you can see some of the homes in Forest Point. As I mentioned, we're kind of meandering west in these photographs. At some points on the property, the area between the Forest Point lots and the creek is wider than at other points. And some areas are open and some areas have vegetation such as these trees. Now we're getting very near the area where the grass was overgrown and to where we stopped our tour. And you can see in this photograph how in the foreground the grass is shorter than that in the background, and that's where we stopped our tour on Monday. And this is at that point where it gets a little bit taller. As we discussed at the meeting last month, the applicant will be required to give a presentation to the board outlining his reasons and outlining the request and outlining the reasons for those requests before we have the public hearing. As I mentioned, if you have any questions for myself or any of the other staff members that are here, we'll be happy to answer those questions.
Okay, thank you, Mr. Baumley. Questions for Mr. Baumley? All right, thank you. All right, Mr. Cantrell, I think you've been elected to present this on behalf of the applicant. If you would, please come forward and state your name for us and any comments that you might have.
Yes, Chairman Rogers and members of the board. My name is Rick Cantrell, and I do live in the Saratoga subdivision. And I'm going to use the city's GIS mapping, if that's okay, to point out a few additional things for us today. We scale over to it, and then he'll put it up. Oh, he's already got it up. Okay. We're in the area that we made the request for, and quite frankly, the basic reason for our request today is that last year we were cited to court for failure to mow the area as requested. If we weren't being cited and being complained with about cutting the grass where it's not being cut, then we probably wouldn't be here today. I know that there are several areas you can see in the photograph where folks are, I guess, borrowing the land without objection, without permission, and they are maintaining it back to the creek and mowing it. There are some areas, though, that we don't have direct access from our property onto this property to maintain it. We would have to go across other people's property to get to this area. So I want to be clear that that's why we're here. We're not here just because we want to create something behind someone's house that they don't necessarily like. We're here on a reactionary basis almost. I want to go over to the topo maps of this area, and I'm going to use the cursor to come around. Of course, this is Forest Point in here, and here's the creek in the blue line coming around through here. Hope you can see the cursor coming around through there, okay? And this contour here, this red one, that is a 590 contour, and if you look, that is just an area that has been was excavated when the Forest Point subdivision was developed. And that excavation occurred to place fill on the lots in this subdivision so they would become out of the floodplain. The floodplain elevation here, I think, as I recall, is about 594. And this water, this large area through here, as you can tell up against the creek, is, it's not falling. There's not another contour line between it and the creek. So it's excavated down about as low as it can go without the water from the creek coming over into it. So it's going to hold water for some period of time. And in my experience of being working for the city for several years and working in land development, when pieces of property like this are left at that elevation holding that water, and we'll show you a picture of that off the city's aerial when it was on there just a while ago, you can see where it's ponding. Then it takes on the characteristics for plant and animal life to be classified as wetlands. And we have an area like that within the balance of our property that was borrowed from and excavated. And today I would figure that TDEC would classify it as pristine wetlands because it does have the plant and animal life running through it, and that is pristine in my opinion. I've dealt with wetlands in the development process several different counties, including Rutherford County, Davidson County, Sumner, and Williamson. So I have a little bit of feel for what's going on with it. Of course, you got the hardwoods wetlands, and we have a part of that also. So is there any question about these topo lines and what you're seeing there as it's adjacent to the creek?
Mr. Cantrell, I would venture to guess that your guess would be, or your, for the lack of a better term, contention would be that that area next to Lytle Creek that's within those topo lines that you are outlining would be defined as wetlands?
That's my opinion.
Okay.
And I think that would be the opinion of the city staff. I think that would be the opinion of TDEC as well. It's wet in there. It shows ponding in there. So that would be my contention. The floodplain is going right up to the back of those lots, that 100-year floodplain. It was filled up. I think the elevation is 594. So that's what it's getting to. And those lots were created. There's a sharp drop-off from the lots down to this area. The floodway itself is probably only about, I suspect, 75 feet wide off the top of bank in that particular area there. If we can go back to the map, please. And as you can see, the areas that we were looking at that were well maintained by the adjoining residents, where my cursor's coming along through here, over around and through here, it has fall into the creek, and they, enjoy that back a distance, whatever they've elected to mow over the years. So, we don't know where the complaints are coming from or so we just included the whole area along through there, not knowing where the problems were coming from. But you can see that it's falling, and then you hit that 590 contour as it comes around, and it's actually right at the stream bank. So yes, that would be the area. And then if I go to the aerial of this, I can zoom in a little bit if needed, but you can see that right up in here, that body of water. Can y'all see that okay? Should I scale into it a little bit?
I'm not sure what you're going to show us.
Well, it's a body of water. It's a different color green than the green
Yeah, you might
of
want
the
to
trees
zoom
that
in
you're
a little.
seeing.
Yeah, it's hard to see for me.
My
anyway.
cursor is right there. How about that?
Better.
See that pretty good?
Yes, sir.
And that's probably one of the deeper spots. It may be 6 inches deeper than what you see down through here. I think these contours are on 2-foot intervals. So this area here is still going to stay marshy. And then here we are back to this. So that would be an area that I definitely feel would be considered a wetlands area. This is right through here, as I'm pointing out to you. The other part of the exemption request for which you can consider is if it's wooded area. And I think you can tell that this area, as it comes along through here and also kind of wraps within partially the area identified as a wetlands, is wooded. You can kind of tell it goes over the property lines. I'm not sure. Well, this where my cursor is now, I think that's a part of the Dairyberry Farm, and they front out on Southeast Broad Street, and it's wooded, and it stays wooded as as it goes on towards Saratoga. My backyard actually goes right up to the wooded area of the Dairyberry Farm and becomes wooded with privet hedge just right at the property line. And that's true for me, my neighbor, and a few other neighbors on down through that common property line. There's not a transition area of clean-cut lawn or anything. Your yard's mowed, and then you're immediately up on the wooded area. Sparsely wooded. Some trees look nice, some don't look so nice, and a lot of privet. Fight the privet quite often. So I would think that this area would probably be considered, as well as over in here. I'm not sure who the property owner is through here. I think it's the Murphy family, but I'm not 100% sure. This is the co-op over in here, as you can see, and of course this is the church property, and it's all wooded. And we probably have exemption from the mowing ordinance because of it's being wooded. So after your deliberation today, if you don't have any questions about the maps, the wooded area and the wetlands area, it could be that you would consider a portion of this property to be wooded and wetlands, and the other portion of it to be still being borrowed and maintained by the property owners without objection by us. It's never been a problem for us anyway. When I say us, I mean the Saratoga Park Homeowners Association, for those people to borrow that property, cut it, play on it, go to the creek or whatever. But when it comes to us being taken to court for failure to maintain, then we're put in a position to say, how are we going to do this? We've got to cross other people's property. The one property owner may say, we'll give you an all right to go through there, but some of the properties are fenced. You can't really get around them to get back in there and cut it. I really don't know where the complaints have come from in the past. I suspect, and in talking with Mr. Woods, we suspect that it is a complaint referral basis. I don't think that the city inspectors have ever known that this area was back there because it's not readily visible from the streets. And that's our presentation on it. How come we're here? I'd be glad to answer any questions.
All right. Thank you, Mr. Cantrell. Any questions for Mr. Cantrell?
The area that's close to this pond down there that looks as if it started to grow, not really being maintained as a yard. Has Saratoga Park ever, or the homeowner association, ever maintained any of this property over there? I mean, I'm not sure how long these subdivisions have been there and how much growth there. It looks like there's been some maintenance when it's grown up some, but it looks like it's had some attention at some point.
Okay. I've lived in the subdivision for about 12 years, and I've served as the president of the board on 3 different terms in there. And prior to all the homes being built on the lots in there, we just trespassed across the lots that were still owned by a builder or the developer or whoever, and went there and mowed a certain distance around through there. And in that time that I was living there, those folks that, the ones that are probably on Boone Court, they were already borrowing the land and mowing certain portions of it. The part that's closer over to the common boundary line with the church, those were some of the latter lots to be built on up, as I recall. I don't know the exact dates. And we mowed, when you got down into below the 590 contour, it stayed too wet most of the time to be real effective in there. And I think even prior to that, at some point they got hay off the property. Because I know in our area, that's what we used to do, was let folks cut it for hay. And that worked well for a while, and then we had the one year where nobody wanted to cut it for hay, and then after that it it just wasn't worthy of someone coming in there and getting, I think it produced, I don't know, maybe 60 or 80 round bales, so it was kind of, I don't really want to mess with it. So now we've had to cut it at times. We try to only do it about twice a year at most, and then we cut around our trail about a 6-foot strip on either side of it, and it grows up, pretty good at times. So there was an occasion, to answer your question more precisely, when that was done. I think Jim's been present for a while. It may have been, when's the last time you?
I've lived there for 11 years, and I've only known it
Mr. Wood, do you mind going to the podium so that the microphone can pick it up?
I've lived there for about 10 years, 11 years now, and I've only known it to be cut one time. We were able to get a bush hog in there. We had to go over property, and it's pretty rough. Like I say, it stays wet, and it's hard to get equipment in there to even do that. So, like I say, one time's all I know that it has been cut.
And you are Jim Wood?
Yes, I am.
The pictures that we have, that I see,
Right.
it looks like the property's been mowed.
There are several property owners that their property backs up to ours.
In Forest Point?
Yes, sir.
Okay.
And they do mow to the creek. And we have no objections to that, for them borrowing our land. That's where water, those lots you're seeing that were mowed, they don't have any water in them.
Okay.
They're not a flood area as far as, staying wet year-round.
Look at that. That picture looks like it's just somebody's yard there. I assume it was a picture taken of the property in question, but it looks like it's been cut and cut regularly. So we've got lots of pictures through here that just depict the area in question, but that have obviously been mowed by people that live in Forest Point and adjoin the property.
Right. Towards the end of the pictures that I showed you, there comes a point where it does not appear that there is any maintenance, and the grass is looks like it's more routinely mowed the further east you go, and the further west you go, the more grown up it is.
Like that.
That's near the area. If you go a few more pictures, you'll see where the grass is shorter, and then all of a sudden it gets taller for the balance of the track, heading up north and west towards the church track.
Nothing I was going to mention on the wetlands, which is one of the issues to take into account when looking at these. Is that's something that the state will decide that if it truly is a wetland, then something needs to be.
I think I would defer that question to Mr. Sam Huddleston from our engineering department.
Chairman Rogers, member of BZA, Sam Huddleston, City Engineering Department. The question on wetlands out of the ordinance, there is an automatic exemption for areas recognized as wetlands. Mm-hmm. In the information that Mr. Ives presented to the board at our last meeting, one of the things we suggested in there was that this board might want to consider the presence of wetland or wetland type areas in your deliberations on whether to grant an exemption under this request. We do not anticipate calling the state in to ask their opinion if this meets the definition of a wetland or not.
I do think we're curious about your opinion. Do you think it meets the definition?
I think a large majority of the tract that they've asked for an exemption on exhibits characteristics of a wetland. And there are basically three characteristics. That there have to be wetland-type plants, There have to be wetland-type soils, and then there has to be water. And so and some of you were present for the tour, and the plant species we see down there, like wet feet, the soils that we saw and some of the areas we looked at exhibited wetland characteristics. And then, of course, from the aerial photography and from our experience with that area, it does remain wet for a length of time that would make it meet the definition of a wetland. But we have not asked that opinion, and we have not secured, the Saratoga Park Homeowners Association nor the City of Murfreesboro has secured professional services to answer that question.
Mr. Huddleston, I'm sorry, go ahead.
I was just going to say, the state body is who would actually make the final call as to whether that's...
Well, it's only in the issues of if you're looking to disturb a wetland. Do we normally call them out? A wetland is a wetland by definition. And if you're working with a development track, and Mr. Cantrell mentioned this in his experience and our experience too, you will get the state and or the Corps of Engineers to confirm the areas of being wetlands, but that's generally tied with a permit application for them. They wouldn't routinely come out and delineate wetlands to perhaps answer a BZA or a zoning issue at the city level.
Okay. Would you say all this area that was hatched here in the drawing that would be?
Not all the area. The request that the Homeowners Association has turned in is about 10 acres, and there are certainly upland parts of that or parts of that do not exhibit wetland characteristics. But a good portion, and I think Mr. Cantrell was probably on track with his in his presentation. That the lower portion, the portion, I guess, to the west and lower parts of the site.
You just answered my question. My question was going to be, would your opinion be that the wetland, as you would define, go outside of that, if we pulled that map back up, the red portion of that topo map, but I think you just answered that question.
Yeah, some's in, and some
Right.
of it is in, and some of it is out.
Right.
Yeah.
And just so I'm clear, he showed a 591 contour line there, and more or less, is that what you would think would be the area in which would be classified a wetland, or is it that clear?
Well, I don't know we've cut it that close, but it is certainly from the topo, you could identify an area and say, boy, this is very suspicious. Mm-hmm. It appears wet all the time, and the grades and the topo and the elevation suggest that it would be that. And reminds you that a wetland is exempt automatic. We don't have to. BZA doesn't have to take action on a wetland. That's an automatic exemption if you'll back up into the ordinance. And that's there to protect that wetland from disturbance because of mechanized maintenance. State really doesn't appreciate wetland owners putting large tractors and bulldozers off into wetland areas and disturbing those areas. So we wanted to make sure that our property maintenance code matched up with the expectations of the state of Tennessee on some of their environmental rules.
In addition to the wetland as being automatically exempt, there are three others: a water quality protection area, a stormwater management system, or a heavily wooded area.
Correct.
Does any of this property qualify under any of those other three categories?
The heavily wooded category certainly, and I think Mr. Cantrell hit on that in his presentation, but I think we'd certainly recognize as staff that a good percentage of this property is heavily wooded and cannot be, and we don't expect it to be maintained because there's not a presence of weeds or grass in there. It has not been designated as a stormwater management area or on a site plan or anything like that. It was part of the original Saratoga Park homeowners or common area. And I'm not sure that the plans really talked about a management strategy for this area. It did include the amenities that we've already discussed, the pool house, walking trail, and those things. A water quality protection area, that area exists on this site, however, is not designated as that. And I want to make that a distinction, that to be designated as a water quality protection area, it has to be tied to property development. It was an amendment we made to our stormwater ordinance 3 or 4 years ago. So there has to be a development intent. Well, obviously, this property was developed in the late 80s and early 90s, and so we did not make it retroactive. And why is that important? Well, the streamside buffer is what we're talking about, a zone of about 50 feet from the edge of the stream. We do have a stream in this area, and so from the standpoint of protecting the water quality of the stream, it's beneficial to leave that area undisturbed. So we have the area that meets the definition of a water quality protection area, but it does not get the designation because there hadn't been a development plan on the property. And I think to add just a little bit more to that, in the memorandum that Mr. Ives handed out at the last meeting, we think that that's something that'd be reasonable to consider, is the presence of streams, the presence of buffer zones on those properties. That'd be something to consider and say, yes, maybe that's something that we could look at and take as evidence about the request. So the buffer zone is there, the stream is there, the wetlands are there, and the heavily wooded areas are also in there.
Well, who determines that it's a heavily wooded area?
Not sure that I know how to answer that question, Mr. Ives.
I think that's a determination that this board would make from listening to the reports about it, from looking at it, from seeing the overhead photos of what the area looks like.
I think that area counted as a heavily wooded. The sticks there.
Well, if it meets the definition of heavily wooded, we don't even have to make a decision on that component of the property.
That's correct. It's exempt automatic.
exempt.
It's automatic exemption. And I think from a practical standpoint, heavily wooded would mean, to me, difficult to maintain with normal maintenance equipment, lawnmower, tractor-mounted mowing equipment, those sorts of things. Certainly, if you can't get a piece of mowing equipment in there, it's probably heavily wooded.
I just think we somehow need to delineate what component of this application is, quote, heavily wooded, and say we're not addressing that component because it's automatically exempt. But unless I don't see where the board makes a decision or defines it as heavily wooded, and maybe.
And I think that's correct. I think what we have in front of us is a request by the property owner to allow this 10 acres to return natural. Whether it's wetland, heavily wooded, stream, water quality protection area, or backyard, they've asked the request before this board is the whole 10 acres. I think you're correct that we don't have to go back and divide each one of those. But there is not likely a property maintenance violation if they don't mow the heavily wooded area or if they don't mow the wetland area.
Okay.
But they've requested the full 10 acres.
But there may be some area, in this instance, looks like there's heavily wooded / wetland area, then you maybe get outside in the wetland area that's not heavily wooded, and then there at some point that you may not be in either one of those areas that's going to abut the Forest Point subdivision.
That's correct, and those are the areas probably most in question today.
Right, okay.
Okay. Any other questions for Mr. Huddleston?
If anything else comes up, we'll be right here and be available for additional questions.
Thanks, sir.
Chairman Rogers, you referred to the photos earlier, and that's part of the area where I said the property's being borrowed. And when we get cited to mow, we're getting cited for the parcel, okay?
That was my question. You're getting cited to mow the whole parcel.
We're getting cited for the parcel, and So I'm not sure where it's coming from. My suspicion is, though, it's probably not coming from those folks who are enjoying, mowing back through there where it's obvious that it's not wooded or wetlands fringe or any of those other areas. I think it was mostly that area that's probably along, and I'm just giving you my opinion, that's along the western borderline of the property that is between us and the Murphy property, or adjacent to what I think is the Murphy family property, or it was at one time, and over next to the co-op track in there. And we're certainly open to the compromise situation, because I know that there's probably folks here that says, I've enjoyed this property for a while, I don't want it grown up right behind my yard. And that would be fine with us probably, is they wanted to continue to borrow the property and maintain the property. Be no objection at all.
So
But that's why we're here today.
the people that cut it, the people that cut it can continue to cut it, even if the BZA says you can let it grow up. They can, according to the Saratoga Park Homeowners Association, they can still cut it if they want it.
We would probably, I don't think there'd be any objection from the board regarding that. Now, if we're left with a strip somewhere at one spot where someone says, well, we've determined that this 15-foot strip doesn't classify, and it runs for 300 feet in length or 400 feet in length, and we still don't have access, and we're going across somebody else's property to get there, then, we'll be back in court. Thank you.
Okay. Thank you, Mr. Cantor. Mr. Wood, thank you. All right. At this time, we're going to conduct a public hearing. Anyone present wishing to speak for or against the application, if you would, please come to the podium, state your name, address, and any comments that you might have.
Hi, I'm going to speak first. I'm from the Forest Point Homeowners Association. I just want to mention that anybody else that is here from Forest Point, please plan to go ahead and speak after me as well. My name is Mary Ellen Posavon. I'm a member of the Forest Point Homeowners Association Board, and one of many people in Forest Point that have brought these concerns to the attention of the city and the Saratoga Park Homeowners Association. I think I'll start by just addressing the points in the application. First of all, though, I want to mention that Saratoga is mowing and maintaining similar property that could be classified similarly on their own common area. And in fact, there is a bridge abutment that used to have a bridge from the common area that they use for the walking trail and tennis courts and this portion of the track behind Forest Point. So originally the plan was for them to have a bridge to go across and to use this land. At some point in the past, that plan changed and the bridge was actually torn down. The cement abutments are still there. So, and since then, I guess it's been used for hay, and it has been mowed several times. In fact, when I moved in there, it was mowed at least once or twice a year. It's just been in the past several years that it's been consistently neglected. I want to mention the flooding, since that, and the water issue, since that's come up in several different contexts. We did have a beaver dam problem, some of you may be aware of that was down below the area, or I should say above, north of the area of the pond. And it wasn't on Saratoga's property or Forest Point property. And so a lot of the issues that you see or have heard about regarding water were because of the beaver dam. The beaver dam was taken down by the city and the beavers were removed a year ago. And since then there's been no flooding and no standing water. It simply drains. So, sorry, thought someone had a comment there. And so I think you should take that into account into any discussions of a water quality protection area or a wetland. Pretty much it was a problem with the beavers. It's not a natural feature of the property. I want to show a couple pictures that are quite a contrast from pictures that were shown earlier. This is directly behind my house, and I think somebody probably can put that up. And you can see that's my privacy fence and just how high those weeds are. I'm 5'8", and they're above my head, some of them. And so obviously some people are mowing. You can
He's
help
going
me?
to come and zoom in for us.
Thank you. Thank you very much. So some people are mowing, or as Saratoga would say, borrowing land, but nobody is satisfied with that. The people who are mowing are going to significant personal expense to maintain property that they neither own nor can use nor can sell when they go to sell their properties. It's really akin to me not mowing my lawn, having my neighbors step in to do it, and then say, well, it's fine because they're doing it, and I shouldn't have to do it anymore. But they don't own my land, they can't sell it, it still belongs to me, and they can't use it. So obviously people like me who are not going to this expense to mow the property are dissatisfied with the dangers, the fire danger, and unsafe conditions and unhealthy conditions behind the property. I'll show a similar picture that just looks the other way. I just turned around from the other picture, and this is looking the other way. To give you some perspective, the last picture that Mr. Blomley showed some of this growth in the distance, and this is actually when you're up in the middle of the growth. Any questions so far? Okay. And as you question quite a bit about which portion is wooded, which portion should be mowed. It's true that a portion of the property is wooded, and obviously there is a pond and there is water, so nobody's saying that Saratoga should mow a pond or mow a big tree down, but there's a significant portion that needs to be mowed. It wouldn't be obviously the entire 10 acres, but the portion that is adjacent to our homes should be maintained by the Saratoga Homeowners Association as the landowner of that property. I want to mention also the issue of property values, and as you know, we all do our best to keep our property values where they are, but this is a property value issue for us. For the homeowners that are mowing, they would have to say to any prospective buyer that they don't own that property, yet the prospective buyer would have to mow it if they wanted to keep it up. For people like me who don't mow, I really can't imagine putting my house on the market right now and having buyers come and look at the eyesore that's out the backyard. In fact, I have a picture from my back porch. Unfortunately, my printer, thank you, whoever's helping me with this. The printer ran out of colored ink at the wrong time, but you can see looking out the backyard just the eyesore that all of those weeds and grass are. And so it lowers property values for my home specifically, but then also indirectly homes in the neighborhood whose price would be based on obviously comparable values of other homes. So that's a significant concern obviously for the Homeowners Association from a Forest Point, because a lot of our work revolves around issues of keeping our neighborhood and home values up. And I want to mention also that there was a fire on this property in 2008. I don't know if this is worthwhile to show, but it just gives you an idea of the incident that occurred. It was in 2008. It was directly behind, let me move this up a little bit because I'll show you. Right here, the open land or field. It was behind Boone Court. And so I understand that Saratoga did receive a citation at this time, and this issue is what prompted several of the homeowners to step in at their own expense and begin to maintain that property. And it's been a significant expense for a lot of the homeowners. And obviously, for those of us who just haven't been able to go to that expense, we're very concerned about the fire danger. And I understand that there's a fire marshal here to speak to that today. There's also problems with ticks. When I mow my lawn, I get ticks on me, which obviously most people don't have to worry about that mowing their lawn, but the ticks are just in that area and come into the yard. A lot of homeowners have problems with mice and snakes. A lot of people that have mowed because of snakes. And it could also be a haven for rabid animals that could be living out there and would be given shelter from the tall weeds. I want to mention also, of course, you all are familiar with the city code, but something I mentioned to our homeowners is that a tract should be cut within 50 feet of improved residences. So that's the minimum that we're asking for. Of course, in some areas it may be necessary to mow further than 50 feet from improved residences. And I guess the last thing is that we're really appreciative of Saratoga that they have not had an objection to people maintaining the property, but at the same time, it's not fair to compel people to maintain other people's property. Once again, they can't use it and they can't sell it, so it doesn't belong to them. Do you have any questions for me?
I do. Tell me, what was your last name again? I'm sorry.
Pozzebon, P-O-Z-Z-E-B-O-N.
Pozzebon. Okay. Ms. Pozzebon, you'd said that for the past several years it hasn't been mowed. Can you give us something more specific than past several years? When's the last time you recall it being maintained by?
I would say probably 2007 is the last time that I remember it being mowed, because I moved there in 2006, and I believe it was the year after that.
Okay. And maybe you can help me with this too, because when you go out there and you walk this property, it seems pretty. It's a line right at the end of Boone Court, which I think seems pretty clear. Splits those two properties at the end of the cul-de-sac there. Everybody east of that maintains this area, and it seems like everybody west of that doesn't. Have you got some history on that? Why that's the line? Why that is? It seems pretty obvious that that's what's going on, but it seems like half your neighbors say let's maintain it and use it, and the other half say we're not touching it. So I thought maybe you might give us some history on why that line of demarcation.
Well, some others who live on Boone Court are here today, and perhaps they could provide some insight as well. But as far as I know, it's really just a matter of coincidence. And I think that one person on Boone Court only is maintaining it because their neighbors are maintaining it and they feel an obligation to do so. But once again, they have to go to their own expense to do that. But yeah, I mean, it's actually, I do have a neighbor on Forest Point that's mowing a portion, so it just was beyond what you could see.
So you also said that, and I think you correctly point out that if your neighbors are maintaining the property, they don't own the property, they can't sell the property, they obviously have to disclose that to anyone who is a prospective buyer. But you also kept saying that they can't use the property, and it looked like to me that Saratoga was allowing the use of that property for those who maintained it and wasn't objecting to the use of the property.
Well, I mean use in terms of putting any kind of structure or even a temporary structure on it, or putting a privacy fence and letting their dogs run on it, for instance.
So you mean you couldn't erect improvements on it, but they were allowed to use it if they maintained it. It looked like to us when we were out there that plenty of people were utilizing the land.
Well, I guess it depends what you mean by utilizing. I don't think that anybody's utilizing it except for going to the trouble of mowing it. I don't think anybody's...
We saw fire pits. We saw trails. It seemed to me that people were down at the creek using that property for,
Animals make the trails, and I did see one fire pit.
Well, I'm not going to argue with you.
I
mean, the animals didn't put in stone trails that go back to the. But I'm just saying it looks like to me people were back there and enjoying. At least some of them were. I guess my question is: have you been told by Saratoga mow it, but don't use it, stay off of it, or? That's what I'm trying to get at.
Well, let me give you my perspective, if this helps. If I own the land, I would put a fence on it and make it part of my yard. So that's what I mean by use. I guess there's different definitions. And other people may perhaps put an outbuilding on it and put the mowing equipment in it or something to that effect.
All right. Thank you, ma'am.
Okay.
Council. I'm Lisa Link, and I live at 538 Forest Point, and I'm just at the curve where Saratoga ends, where it abuts to our property. And as Mr. Cantrell put it, I've been happily enjoying mowing the back of my property up until about 3 or 4 months ago when we had a really bad storm, and some of the trees in back of my yard got knocked down into that area, which prevents me from mowing it. Now, I don't have any equipment to remove trees. I'm a small woman. I don't go hauling trees around. That's the only reason that I have not mowed my parcel recently. And so I called the city. I was under the impression when I bought the property that that was a green belt belonging to the city. So I called the city and said, there's a tree down, could you guys come check it out? And they said, well, that's not ours, that's Saratoga. So then I tried to contact Saratoga. I didn't have a number or anything for them. But that's the only reason that my property is in the shape it's in with the trees down and stuff like that. So if I could get someone to take care of that, whoever owns the property, I don't care who mows it, I'll mow it. But that's the only beef I have. Thank you.
Thank you, Ms. Lake.
Hi, my name's Jenny Strassner. I live at 1539 Boone Court. Do I need to spell that for you?
You have a mother that was at Siegel Elementary School?
Yes.
Okay. I know your mother.
I bought the property at 1539 Boone Court in 2008. Some of the pictures did show my property. Mine is the one that has the most trees on it, on that property that's behind the fence. When I moved in 2008, the property behind the fence was not maintained at all, but both of the neighbors on each side was. So I did take it upon myself to start maintaining that property, because after the first year of mice and snakes in my yard, the fenced part, I didn't want that anymore. So I did take it on myself at that point to start slowly clearing out a couple feet at a time behind until the yard, that lot behind my fence, matched the neighbors to make it a little bit more cohesive looking out the yard. So that is where I stand in terms of, I do keep it mowed, but I do not use it. There is a fire pit that was discovered when I cleared the lot, but it is not used. I don't use that lot for anything other than keeping the snakes and mice from my house. So I don't know about other people that are using their lot for fun or recreation or anything like that, but I know a lot of us just keep it maintained to keep the animals out, to keep our yards more usable.
Did you say you mowed a strip, or you mowed the entire thing back to the creek?
I got the entire thing done eventually. It was a process.
How far did you have to mow, push it back, before you stopped having any kind of problems coming into your yard?
Well, I did it until it met the neighbors, just so that it looked the same, more of a aesthetic thing.
But then you kept going after that?
No, it's the same
I see.
as what both my neighbors have. Like, there's just like a wall of grass at one point, so I stopped there.
How far back was that off of your fence, off your property line?
Probably, I'm horrible at estimating. I'm sorry. I mean, at least 50 feet, if not more.
Okay.
It doubles. I guess my property is approximately half an acre, and it's about the same distance from my property line to the back, so maybe an extra half acre.
Okay.
I'm sorry, I don't know exact
That's all right.
numbers. So.
All right. Any other questions? All right. Thank you, ma'am.
Good afternoon. My name is David Valentine. I live at 1545 Boone Court, actually right next door to Jenny. I've been there approximately 15 years, And I have mowed behind there for, give or take, 15 years, for the simple fact of what Jeannie had talked about and what several other folks have talked about. Aesthetics is neither really here or there. Mice, snakes, vermin, that type thing, as well as having young children. I've never, other than being back there on the back side of the privacy fence and throwing baseball with my little boy, ever used it for anything other than just to mow it, because obviously we want it knocked down. And I'm not exactly sure over the years what the ordinance has gone to say as far as frequency, but from what I could understand, the frequency really wasn't enough for me personally. So I just took it upon myself to mow it, to keep it down where I wanted it for, stuff coming in the yard. Another question about I think the lady addressed it about the pond. Beaver problem for about 3 years. So when anybody knows anything about getting ground saturated, it has taken some time for that to dry out. And quite frankly, I haven't been back there since the last time we battled the beavers. But as far as I know, it may still be wet. But over time, I would fully anticipate that to return as it was. I know when I first moved in there was no water. It didn't stand or anything else. Didn't have any problems with that whatsoever. Borrowing the land, I don't know of anybody that borrows it. I'm only going to speak for myself. Again, the only reason I'm on it is to maintain it to my satisfaction, since I don't know that, again, the ordinance propels them to make it look like a yard. But that's why you've got several that look like that, because we mow it, me and my neighbor, we mow it every week or 2 weeks at the most, give that. In response to the petition, I would just request that if it says 50 feet from improvements, then that's what they be held to as owners of the property. Just simply what it says. How far back they go, I wouldn't ask for anything additional. I just think that whatever the ordinance calls for, that's what they should be held to do. Thanks.
Thank you, Mr. Valentine. I think I saw on the fire incident report that you were maybe the person that alerted the fire department.
My wife did, yes, sir. It was actually behind my house.
You tell us a little bit about the fire.
I wasn't there. I was at work, but noticed it, and as it was spreading, of course, they called the fire department. I'm not sure that we ever got a cause of the fire, what happened to actually ignite it. I don't know if it was a lightning strike or what. I never did get an answer on that. I do know that it was mentioned that thankfully that area was not overgrown, similar to what you see on other parts of the land in question, or it obviously could have got out of hand pretty quick with that extra fuel there. And I don't know, but I'm sure that's probably one of the reasons for the 50-foot. Fire folks could probably speak more about that than I could, but I'm sure public safety's probably got something to play in that as well.
So are you saying that at the time the fire occurred, you were maintaining the property just like you described to us in the beginning?
Yes, sir.
Yeah, it was mowed.
Yep.
So it was a grass fire that just started back there?
Yes, sir. And then got onto
Did
the
it originate in some of the brush that's farther back, or?
Well, like Jeannie said, I can't remember at the time if she was there or not, and how much of that she had gotten to at the time of the fire. I know on my side it was maintained. I just can't remember at the time if hers was or not. And then of course it got in the privacy fence. But.
All right. Thank you, sir.
Appreciate it.
Good afternoon. My name is Lisa Lucinski, and I live on Nathan Court. And only a portion of our property backs up to the Saratoga property. And a large portion of our property is backed by a public drainage. And somehow the city is able to get their equipment in and maintain that area. But just beyond that line, about half of our yard, is where the Saratoga property starts. And we do not have the access to go out there and maintain that And that's why we don't maintain it, because when we moved in, we were told that was Saratoga's property. It was not our property to maintain, and we don't have the access from our yard since we're fenced. It was fenced when we moved in. And the neighbors around from us are also fenced, and we don't have the access out there. We were not told that we were going to maintain that, but at the same time, we would appreciate it that it is maintained, because the wilderness is moving into our backyard, and we don't care for that either. The water, when it rained and rained and rained for a week a couple of years ago, it did stay wet out there, but it dried up. The creek has always been there, but the tree line that is there now, that has moved forward because it hasn't been maintained, it was not always as close to us as it is now. The tree line was much further back, and that's just, we would like to have it back like it was when we moved in. It just hasn't been maintained. All right,
Thank you, ma'am.
Mr. Rogers, Chairman, and the Board. My name is Doris Knox, and I live at 420 Forest Point. My property is not directly adjacent to what is being called the wetlands, but I do have an objection to it, and I actually sent a letter in stating that, because I feel without some maintenance back there, we're going to be overrun with wildlife that we really don't want. We already can smell skunks, and you see various things, squirrels and rabbits, and I'm not opposed to some of those, but I feel like we're going to create a breeding ground for some things back there without some maintenance in the area.
All right. Thank you. Anyone else wishing to speak for or against the application? Ms. Posbon, let me see if there's anyone else here wishing to speak. I think I do have somebody else. Let me get people that haven't spoken first.
My name is Tom Hogshead, 550 Forest Point Drive. And, it seems to me like there ought to be a way of working this thing out without lawsuits. I don't like fighting and arguing. Our neighbors over Saratoga are great people as far as I'm concerned, and they came over and said, hey, if you want to buy the rest of this property, we'd be glad to sell it to you at nothing. And the only concern I am is paying the taxes on it, so if I know that I don't have to pay any additional taxes, I'm going to take it, because my backyard goes about 50 feet from the back of my house, and then about another 50 feet belongs to Saratoga. And we put a little swing set back there and built a little park area, and we watch the duck, and we have a heck of a good time back there. We're happy the way it is. And I think maybe 99% or 95% of the people here are the same way. If you couldn't just work out with those individuals who have a problem on some sort of basis to make them happy, then maybe we could just pass over this thing and go on about life. But it seems to me like, why are we quarreling? Let's just work on who is unhappy and set aside those people. And I'm tickled to death the way it is, but I know some of them aren't, so that's okay too. But let's see if we can settle them and just wash it away.
All right. Thank you, sir. Anyone else wishing to speak for or against the application? All right, Mr. Posbon, I'll give you another 2 minutes.
I neglected to mention that there is a homeowner at the end of Forest Point without a privacy fence who's given permission for Saratoga to cross their land to mow. If that homeowner ever moves or anything like that, I'm sure there would be plenty of other homeowners that would be happy to provide access to Saratoga. I would be myself, but I have a privacy fence. Probably hard to get that equipment back there, but that shouldn't be a consideration because it can get mowed. Thank you.
Thank you. All right, at this time we'll go ahead and declare the public hearing closed and open the floor for further discussions or motion.
Mr. Chairman, can we ask the fire marshal to step to the podium and talk to us about this 50-foot buffer that several of the folks who spoke raise those issues, and since we had an actual fire in the backyard, maybe you can, I don't know if it's fair just to ask you to talk about it if you want me to ask you a particular question, but I guess I am curious about any concerns you might have based on the pros and the cons we've heard.
Okay, well, I'll give you my perspective strictly and purely as a, on the fire side. I'm not either side of this.
Right.
We did have that fire back in September. That was undetermined, strictly a grass fire. Now, we do have some nationally recognized standards that deals with reducing structure ignition hazards from wildland fires. And what this recommends is a 30-foot buffer from any structures, which I would consider a fence as part of that code. I did get a chance to go out there and look at that this morning. I did see some of those areas that were cut back, and they were real neat. Don't have a problem with that. But the ones to the east, at the end, or to the west, at the end of Forest Point, where they were grown up next to that fence, I consider that a hazard. And according to this standard, I think 30 feet would be a minimum that needs to be cleared, and also that has to be maintained.
Any other questions?
That's what I wanted to know. Yeah.
All right.
Thank you.
Ken, thank you.
Thank you.
Matthew, help me get a little bit of the lay of the land out there. So as far as the boundary that is, I guess would be the southern side of the Forest Point, that is essentially pretty short, been cut pretty short, maintained largely by the homeowners. It's when you swing around to the western side, that's where we start running into Ms. Posabon's property, and the grass really abuts more closely, tall grass more closely the property at Forest Point.
Yeah, if I may, I'm going to step back up to the podium.
Sure.
and show the aerial photograph and the kind of the area of demarcation, the line of demarcation that Mr. Dodd was referring to earlier.
And while you're walking that way, consider the buffer that was talked about, a 30-foot buffer. That's almost exactly what I was thinking about in terms of some sort of solution to the problem. Would pushing this off these property, I do think it's unfair to have, and probably a little bit dangerous to have, that condition existing up against a wood fence, and probably would be uncomfortable with that myself. Pushing it off, is that pushing it off, say, 30 feet, allowing them to grow up the rest of the property, but just having this 30-foot buffer along the perimeter, is that something that would be feasible?
I think I would defer that question to Mr. Ives as far as how our new ordinance speaks to that.
I know we can grant the application in part or in whole, so I assume in part saying we can grant it as to 8 acres and not the whole 10 acres. Is that fair?
Yes, that would be feasible from a
ordinance standpoint.
From an ordinance standpoint and from a BZA action standpoint. Whether that's feasible
that's my question.
From the property, from Saratoga Park standpoint, I wouldn't know. Certainly, I think the further away you get from the fences and the closer you get to the creek, the wetter it's going to be more often. And whether a strip near that close to the fence would be maintainable with reasonable kinds of equipment or not, I would not know.
Well, the other thing along that line, one of my biggest hang-ups, and I know Ms. Posabon says we shouldn't consider it, but I think we have to consider it. Part of the application says the burden on the landowner to maintain it. I want to balance the interest, but if we tell them they have to mow a 30-foot strip, but they've got no legal access to the property unless they pull up their pants legs and carry a mower across the creek.
Well, I believe
we make them build a bridge.
They have got the legal access across the part that we walked on Monday. That was their property, and I don't believe, from the starting point of the Forest Point area over to somewhere around Boone Court or a little past,
have to go
You
all the way
can
around.
drive a small tractor, I'm not sure about a huge one, but you can get across that, and there's very few, other than right after big rain, there's not going to be wet areas in there. It's after that is where the wet areas start, and of course, that's their property. They can access from that.
How do they get there? Are you saying where we went across for the view, that's their land, or they have an easement back to their property from that access point?
There was a city easement that got us from Forest Point Drive back to
Yeah, it's the
Saratoga's.
cities there.
Yeah, that got us from the street. We're assuming.
Yes, I believe there's access through that berm from the Saratoga side. Is that not right, Mr. Cantrell?
News to me, Mr. Ives. Could be. I'm not saying yes or no. I got no clue.
Well, we did walk that a couple weeks ago, and I thought that there was room toward the, I guess that would be the southerly end of that berm and tree row there that's between the two subdivisions.
I don't think Saratoga has ownership as an HOA of that. If you're referring to a storm range easement that was granted to the city,
Think-
can I then use that for access?
Can we bring up that picture?
Yeah, I think what Mr. Ives is referring to, if we could bring up the aerial photo, is this area here that's a part of the overall tract, but that's south of the bulb of the cul-de-sac of Saratoga Drive, or Saratoga Drive. And there's the kind of the dividing line between the two subdivisions.
A tree row that's up somewhat on a berm between the two subdivisions. And that, yeah, the property to the east is part of the Saratoga property, and it continues straight on to the west. Nick?
Well, it becomes very narrow as you go west, and then its access point back to the east, I'm not quite sure where that service is at. Because it's right up on the bank, the property lines are right on the bank of the property. Like where Ms. Beckman lives, her property line's right on the bank.
I don't know which ones those are. Sorry.
So you're saying, Mr. Ives, that they have other property that abuts this property. So from a legal standpoint, it's not landlocked from their access, but where there's a practical way to get over there is the other question.
Correct.
Chairman Rogers, you had asked before about the area that appears to be maintained versus the area that is not maintained, and it's right around here at the end of Boone Court. There is kind of an area, it's kind of a, I think Mr. Dodd, line of demarcation where to the east is predominantly maintained and to the west and north is predominantly not maintained. And I'll show a couple photographs. And you can see here, this is, as I mentioned, this is kind of the extent of where we took the tour on Monday. You'll see that beyond this point, the grass is much taller than.
It's the DMZ.
Right. Right. That's it. And then here's kind of more of a close-up. You can see it's mowed up until this point, and then after that point, the weeds and grass are much taller. I believe those houses that you're looking at in the background are on Nathan Court, I believe. It's the backs of those houses.
Is that correct, that the houses we're looking at are at Nathan Court?
Yes.
Okay, thank you.
Okay. I mean, I don't want to track the 30-foot buffer too far if it's not going anywhere, but if it may be heading somewhere, I'd like to hear from Mr. Cantrell as to what he believes the feasibility of cutting a 30-foot buffer along the property boundary might be.
I like the 30-foot buffer. I think it's a good balance. I'm willing to consider that, but I I'm not saying I've decided one way or the other, even if it's depending on what we find out about the feasibility, but I do think it's fair to consider that for the homeowner, the property owners, is, how are they going to get back there? And I don't know who created, obviously this is kind of a mess, is the fact that they own it and don't really have a good way to get to it. So, I don't know who created it, but it is what it is now. I think some sort of buffer is a fair position for us, because most of any sort of wetlands and heavily wooded areas would be beyond that 30 foot. It would seem to be a good balance.
And some of this has been maintained in the past, and maybe access has changed and how to get to it, but there's been equipment back there at some point.
Ms. Posbon said it was 2007 the last time she remembered it being maintained on any sort of regular basis. And then I think the testimony was that it had been accessed through various lots that were still in developers' hands or whatever up through that point. So I don't know how it was to that point, but obviously it's a challenge, and I don't mind that, frankly, being a challenge to them to keep that 30-foot buffer, but I don't want it to be a legal, impossibility, and us put it on them to say you've got to do this 30-foot buffer, but you don't have any way to get your equipment back there.
And is the 30
do that? So I don't.
Is the 30 feet going to be out of the wetlands all the way through there?
It sounds like 30 foot's still on the table, so if you want to come up and tell us if it's possible or impossible.
That's quite a question, Chairman Rogers. Possible or impossible. And I'm not aware of the easement that she referred to that someone said we could use. I guess it's along just coming on their property, but where Matthew was trying to describe to you at, that opens up, to a spot on the open space that's at that little bridge that goes in. It's a low water bridge, I guess, for lack of a better term. It goes over, it floods and water goes over the top of it occasionally, and it's that access point, if I were using all of our common area, would be at that spot. And the distance available, and you can tell it because...
Before you go on, can I stop you? Are you talking about over by the tennis courts?
Yes.
So that would be your access point, you're saying?
That's my common area access point. And so that access point, unless someone in the next... Of course, it drops off so much on some of those houses. I have to work out some arrangement to go across private property somewhere else. But at that access point, at that little bridge, the distance between the top of the bank and the property line, and I know the property line because the phone and cable in this particular time frame is built on the rear property lines, is maybe wide enough for an 18-inch wide push mower to go through there. And you would travel that distance parallel in the creek in an effort to get, you go behind, I think it's called, I forgot the name of the little subdivision, but that's where Sylvia lives and others, and you kind of would come around and follow the creek. But it's very narrow, even behind the homes that, as you first come into Forest Point, that are along the creek through there, that distance between their property line and top of bank is very narrow. Probably the gentleman that spoke, I think I know where his swing is. Okay, so he's on downstream a little bit further. So it'd be a bit of a challenge, but obviously you guys are in a position of making a recommendation, and we're in a position of trying to deal with something we have limited access to. And I don't know, I'm like him. I wish there were a way to figure something out. I didn't know that they'd offered the property to them back before and it's turned down, but that would be more of the ideal situation. I don't, maybe Mr. Ives could figure out a way to have the tax forgiven.
I don't want it to be known that I do have that power.
If that's the hindrance, The other hindrance on transferring properties owned by an HOA board is, obviously, do you have to have every individual that's current owner to transfer that property? Well, you know all those. I don't know that answer either, but we could certainly do a quick claim. Maybe the board could be authorized by 75% of the ownership or something like that, but that's a quagmire, and I'd be open to something along that, but I don't think Forest Point wants to take on ownership either. Doesn't sound like, as a collective unit.
Don't have some
But
good
they
ideas.
do. So, I'm sorry, that's about the best I can answer that question, Chairman Rogers.
Okay. Thank you, Mr. Cantrell. I think the public hearing is closed, and I allowed the applicant to speak. And Ms. Posbon, if you want to come up one more time, and that's it. I requested Mr. Cantrell to come up to speak.
I know, but you have to be fair to both sides
Okay.
of the public hearing. And we do need to respond to the concerns that were addressed and responded to by Mr. Cantrell.
Okay.
As far as access, I know that there's many feasible ways as far as like what he mentioned and the Forest Point homeowners that would allow access, the easement that you walked over the other day, and that shouldn't be a consideration. It should also be mentioned that my home was built in '96, and that was almost the last home that was built in that area. So they did manage to cut hay on it for several more years after that and get access to it somehow. I don't know how that was, and perhaps they don't know how that was. But when they were cutting hay, there was no problem getting access to it. So there shouldn't be a consideration now. And as far as transferring it, I don't think we should really get into those discussions today because no one's here in a position to speak on behalf of the Forest Point Homeowners Association or any specific Forest Point homeowner. And I don't think that we should get into those discussions or make any kinds of assumptions along those lines.
Yeah, I agree.
That's fair.
Okay.
Thank you very much.
Thank you.
All right. Can they use the city's easement to get back there where we walked back through? Do they have that right? I know the city may say,
I don't believe that Saratoga Park would have the right to use that easement. The homeowner could grant it to them. I think that as part of our work for the city and looking at part of what we're looking at is drainage, I think we had the legal right to walk across that drainage easement. But I don't believe that Saratoga Park would have that same legal right to drive a tractor or a lawnmower or anything else across it, or even, frankly, to walk across it without that homeowner's consent. There are other drainage easements throughout this that I'm not familiar with. That particular one we walked across, my recollection is that might not be an ideal access point for even a small tractor and a bush hog. I'm not sure. It might work, but it might not be the best either. So.
All right, well, I think we're ready for a motion.
Chairman, one of, I believe, the BZA's opportunities for action is to defer for further information. If the board is considering or wants to consider a 30-foot or 50-foot or even some other buffer, we need to make sure that we would not force them into a heavily wooded area, something that really is a wetland area. So if it may be appropriate to defer for a meeting for us to do some further investigation, for staff to do some further investigation on that and be able to report back, and perhaps then also work with Mr. Cantrell and try to determine where practical access points are. I think clearly there's legal access, but legal access doesn't always give you practical ability to get equipment into the place.
I mean, I don't think we can force them to cut the heavily wooded or wetland areas, because those are automatically exempt. But I do agree with what you're saying, that, and that's what I was sitting here thinking. I didn't have the benefit of walking over the property like other board members did, and so I'm a little bit of a loss of what the lay of the land is and how possible it is to cut the 30-foot buffer. I wouldn't mind having an opportunity to go out there and look at it and walk over it myself, and then at the same time you all investigate the access issues.
Just as a comment, I think that the 30-foot buffer as a compromise would be a good approach to this, especially when we look at the rules as to, and I know this is not a variance request, but if there is a safety hazard, that is one of the things that we are, as a board, are supposed to take into consideration, and we've already been told by Mr. Honeycutt that based upon national standards that could be the case. So at the same time, though, I don't feel like that we can obligate Saratoga Park Homeowners Association to maintain something that they don't have practical access to. So I do think deferring action at this point would be the best thing to do, based upon, number one, what David, you mentioned about the 30-foot and how, in what areas would we actually have 30 feet, and then second, come up with a way that Saratoga Park Homeowners Association is going to access this in order to maintain this buffer that we're even speaking of. So unless there's further comments, I'll make a motion to defer.
Second.
Okay, we have a motion and a second. Is that like a 30-day deferral to our next meeting?
Yes.
Okay. All right. Very good. We have a motion and a second. Any further discussion? If not, all in favor say aye.
Aye.
Any opposed? All right.
Chairman Rogers, rather than a 30-day deferral, could we get clarification that would be to our regularly scheduled November meeting?
Yeah, I think that's what we
Okay.
agreed on. Yep. All right. Next regularly, we will take this issue back up at our next regularly scheduled meeting. We've already had the public hearing, so we will not reconduct a public hearing at that meeting. We will simply address any the issues that we've talked about with city staff, get input from them, and then debate it among the board and make a decision at that point. So I don't want to mislead anybody that we're going to have another chance at this to discuss this. It's just going to be a debate among the board members and city staff when we reconvene. Fair to say?
But yes, but that it would be open to the public.
Yes, absolutely. Yeah. Okay. All right. Well, we will move on our agenda here. We will now consider application Z11057 by Mr. Derek Wheeler for Integra Creek. He is requesting a variance from Section 26C2D of the zoning ordinance, which requires that parking spaces within garages for multifamily dwellings shall not be considered as required parking unless such spaces are freely available for use by all residents and their visitors. And also a variance from Section 26C1B81 and Chart 4, which require 1.5 parking spaces for each dwelling unit with 1 bedroom and 1.1 parking spaces per bedroom for each dwelling unit, with 2 or more bedrooms for multifamily residential uses. And this request pertains to property in a residential multifamily zone located along the south side of Manson Pike, west of Fortress Boulevard. Mr. Blumley, if you'd review that for
Thank
us,
you, Chairman
please.
Rogers.
It's easy for you to
Good luck.
Yeah.
This is the same property that we reviewed a height variance on last month, south of Manson Pike and west of Fortress Boulevard. The 2.5-foot height variance for the 3-story buildings in a new apartment complex called Integra Creek Apartments. This property has already, or this development has already been through the Planning Commission for both initial design review and final design review. It's located in the Gateway Design Overlay District number 1, so it requires a little bit of extra scrutiny, going through 2 reviews at the Planning Commission level. And as you know, the standards in our Gateway Design Overlay District are a little bit more stringent than in other parts of the city. So it has been approved by the Planning Commission subject to these variances relative to the parking being approved. At the time it was first submitted for initial design review, the calculations reflected a number of parking spaces that were that was compliant with the number of parking spaces required for the number of units and the number of bedrooms that they proposed to have. One of the things that staff didn't realize and that the applicant didn't realize in putting those calculations on his plans were that a number of those units were in garage spaces, and garage spaces in multifamily developments cannot count toward the minimum parking requirements unless they are freely open and available for use by any of the residents of that complex and their visitors. The garage spaces are going to be leased out. Some will go along with particular units, I believe, and others that will be rented on a garage by garage basis as the residents need them. Back in 2009, we did amend our zoning ordinance with regards to parking and included in the zoning ordinance the standard that garages that are not freely available for use by the residents and their visitors cannot count towards those minimum parking requirements. And the reason for that was because we did not want those garage spaces to end up being used as storage spaces, or storage bays, effectively defeating the purpose of including them in the parking calculations. The applicant in his agenda materials has stated that in many Class A apartment complexes that garage spaces are a desired amenity, and that what he has chosen to do in order to accommodate the desires of many of his future tenants is include garage spaces instead of actual open asphalt parking spaces, like as in a parking lot, for example. If we counted the total number of garage spaces that he has on the site plan, which is 92 garage spaces, he would actually be 6 parking spaces over the minimum requirements. However, according to the zoning ordinance, we cannot count those towards the minimum parking requirements. So he actually has a deficit of 86 parking spaces. But the applicant makes the case that this standard, if it's enforced by management, that those garage spaces only be used for vehicular storage, that it's very common for apartment developers to substitute those garage spaces for traditional parking spaces. The formula currently used to determine parking requirements for multifamily residential developments was adopted in early 2006. And this was kind of in response to the number of student-oriented apartment complexes being built around the university. Many of those apartment complexes were 3 or 4 bedroom units that were being rented by the bedroom. And so we went to more of a per bedroom standard for parking for multifamily residential uses. The applicant, and that was so we instituted a more stringent parking requirement for multifamily residential uses. The applicant contends that his demand for parking is actually closer to what our parking standards were pre-2006. Before 2006, a total of 480 parking spaces would have been required, and the applicant is proposing to have 467 parking spaces out in the open and 92 garage spaces. He says that his distance from the university and the type of apartment complex that he's building, which will not have an overabundance of the 3 or 4 bedroom units. In fact, I believe it will have no 4 bedroom units. The breakdown proposed is actually 96 one-bedroom units, 132 two-bedroom units, and 36 three-bedroom units. So the majority of the apartments in the proposed Integra Creek development will be one- and two-bedroom units. So he said that it's really not conducive to being a student-oriented apartment complex, and therefore the parking standards that were in place pre-2006 approximate the number of parking spaces that he will need closer than the current standard. With that being said, if the board wishes to approve these requests, and these would need to be taken in two separate motions because they're two variances from two separate standards regarding the parking, staff recommends that any approval be subject to the following conditions. Number one is a moot point because after these staff comments were written, final design review and site plan approval was undertaken and approved by the Planning Commission. So number two would be the only condition that staff would recommend, that all proposed garages are to be used for vehicular parking. They are not to be used as storage units. And in the applicant's materials, he has stated that on the lease for these garage units, there will be a stipulation that they can only be used for vehicular storage and that they cannot be used for, or vehicular parking, and that they cannot be used for strictly storage of household items and other things. So with that being said, let me just show you the site plan. And here's the entrance off of Manson Pike. And it will also have ingress and egress off of Manson Crossing Drive, which is on the south of the subject property. And on this site plan that you have in your agenda materials, you can see the parking calculations and the breakdown that Mr. Huddleston, the applicant's engineer, has provided. And now just briefly some photographs of the site. This is looking from Manson Pike at the subject property. It's a part of a larger tract that extends all the way to Fortress Boulevard. This is on the newly rebuilt section of Manson Pike. This is the very southern end of the property where Manson Crossing Drive stubs into the property. And this is the Aldridge at Gateway Village apartment complex to the south of the subject property, an existing apartment complex. Another thing that I wanted to point out was that I did put a letter that I received this morning on your tables. It's from Mr. Charlie Waite, I believe, who represents the property owner, and so he wrote a letter in support of his buyer's application. If you have any questions, I'll be happy to answer them. Mr. Wheeler is in attendance, as is Mr. Huddleston, the design engineer on the project.
All right. Thank you, Mr. Blomley. Questions for Mr. Blomley? All right. Mr. Wheeler, Mr. Huddleston, anything you all would like to add to the application?
Good afternoon. My name is Derek Wheeler with Integra Land Company. I just wanted to note that we built a number of projects throughout the Southeast, and the parking standard that's in Murfreesboro is actually more stringent than we're typically used to seeing. So the parking count, including the garages, is significantly higher than what we built at a number of projects. Typically, we shoot for a 2-to-1 ratio. At this project, we're at roughly 2.13. Another note would be is if we came through as a PUD, we probably would not be in this situation with the zoning variance. We could discuss that with staff on exactly the parking count. The adjacent property, Aldridge, literally next door to us, is roughly at 1.86 spaces per unit, and they're not seeming to have any real parking issues, so we're significantly higher than them as well. All right.
Thank you, Mr. Wheeler. All right, at this time, we'll conduct a public hearing. Anyone present wishing to speak for or against the application, if you would please come forward. And seeing none, we'll declare the public hearing closed and open the floor for further discussion or a motion. And as Mr. Blomley pointed out, we do have two separate components to this application, so I suppose it would be appropriate to first consider the request from Section 26C2D requiring parking spaces within garages shall not be considered as required parking.
Mr. Chairman, if there's no other discussion, I move for approval of the variance from 26C to D, subject to the condition that all garages are to be used for vehicular parking only.
I'll second.
All right, motion and a second. That motion is subject to any staff comments, I suppose?
Yeah, he mentioned.
I'm sorry, you said that.
Yeah, I read it for some reason, so staff have comments. But yes, number 2 there, since one was already left out.
Very good, very good. All right, any further discussion? If not, all in favor say aye.
Aye.
Any opposed? All right, we'll now consider the request for variance from Section 26C1B81 and Chart 4. I'm not going to repeat.
Mr. Chairman, I'll make a motion to approve the 26C1BA1 in consideration of the staff's comments there.
I'll second.
All right, we have a motion and a second. Any further discussion? If not, all in favor say aye.
Aye.
Any opposed? All right, Mr. Wheeler, Mr. Huddleston, that application has been granted. Thank you. All right, we'll next consider application Z11058 by Ms. Marcy Richmond, requesting a variance from Chart 2 of the zoning ordinance, which requires a 25-foot minimum rear building setback for principal structures in the RS-12 zone, and this is for property located at 2005 Look Rock Court. The applicant is requesting a 10-foot variance to the minimum required 25-foot rear building setback for a proposed addition to the principal structure. The applicant is also requesting a 3/4 of a foot variance to the minimum required 25-foot rear building setback for an existing encroachment into the rear building setback by the existing principal structure. All right, Mr. Blum, if you'd review that one for us, please.
Yes, sir. Thank you, Chairman Rogers. The subject property, as you mentioned, is at 2005 Look Rock Court, in the cul-de-sac of Look Rock Court. And Look Rock Court is a street that is in the Garrison Cove subdivision. It's in one of the earlier sections of Garrison Cove, very near Las Casas Pike. Here is Ms. Richmond's property at 2005 Look Rock. Ms. Richmond would like to build a sunroom addition onto the back of her house. And you'll notice that her property is actually 5-sided. There's a side property line here, a side property line here, a side property line here, and a rear property line here, adjacent to the property here on Stillwell Court. We determine which of the property lines is the rear property line by determining which property line is most parallel to the front property line. So since it's a 5-sided piece of property, we see that this property line is actually most parallel to the front property line here, and so that this becomes the rear property line, and there's a corresponding 25-foot rear setback that goes along with that rear property line. When Ms. Richmond had the property surveyed, it was determined that there was actually already an existing encroachment into the 25-foot rear setback. SEC, when they performed their survey, determined that this northwest corner of the house was actually 3/4 of a foot into the rear setback. So we went ahead and advertised it as two variances because regardless of whether or not the rear setback variance for the proposed addition is passed, having the rear setback variance for the existing principal structure could help tie up any loose ends for future sale of the property or refinance if a bank or insurance company notices that that it encroaches into the setback and there's a violation, she could end up right back here before the Board of Zoning Appeals to request a variance. So that 3/4 foot variance is for that corner that is already encroaching into the setback. You'll see here the shaded area is where Ms. Richmond would like to build her sunroom addition. There's an existing deck there right now, and there's an upper deck here and then a lower deck here. She's looking for the lower deck to remain, and for the upper deck, that would be replaced by the sunroom addition. You can see just the northwest corner of the subject or of the sunroom addition would encroach into that rear setback. The southwest corner, as the addition would run parallel to the house, would not encroach into the rear setback. So she's requesting a 10-foot variance, as the addition will be approximately 15 to 16 feet away from that rear property line. And so that 10-foot variance would give her a little bit less than a foot extra to work with, a little bit of extra flexibility in placing that structure. One of the things that I wanted to point out on the survey of the property and the plot plan is that you'll notice that the placement of the house as it was built, and Ms. Richmond points this out in her application, the house was actually built about 47 feet or so off of the front property line. There's a 35-foot front setback off of the front property line. So the house was actually pushed back about 12 or 13 feet further back off Look Rock Court than it was required to be, meaning that that back corner of the property that already encroaches, and even the addition, if the builder had actually built the house closer to the front setback line, there may be no need for Ms. Richmond to come to the Board of Zoning Appeals today for this variance, because she very well may have been able to build this addition without encroaching into that rear setback. So that's one of the reasons that she gives for her request, is the existing placement of the house and the fact that when it was built, and she said it was built as a spec home, and she's the original owner of the house, but that she bought it as a spec home after it was already built, and that the builder chose to build it far off the front property line to make it more difficult to build an addition onto the rear. Here are the house plans that she has submitted, the elevations. You see here is the proposed sunroom addition onto the back of her house. And there will be a small landing and outside stairway that will go down to the lower deck, which is adjacent to her existing in-ground pool. Now you'll notice that the landing is less than 13 feet from the rear property line. That landing and the outside stairway, because it's only 3.5 feet wide, can encroach into the rear setback. So that landing would not require a further variance into that rear setback, because it's a permitted encroachment into the rear setback. I'll show you some photographs. This is the front of Miss Richmond's property. This is the property line adjoining her neighbor to the north along Look Rock Court. This area with the railing around it is the existing upper deck, which she proposes to demolish, and then this lower deck will remain the same. And then, of course, here's the area of her swimming pool and the decking around the pool itself. Here's a little closer view of the area of the upper deck where the addition would be built. This is looking at the house towards the rear, the house to the rear of the subject property, which fronts on Stillwell Court. And this is just another view of that lower deck here, which will stay there. And there are some mature trees along that rear property line. Although there is a little bit of a gap in that photograph that I showed you before, there are some mature evergreen trees as well. If the board approves the variance request pertaining to the proposed addition, staff recommends the following condition. A surveyor will be required to help lay out the footing of the building, and a surveyor's certification must be provided that the building addition is no closer than 15 feet from the rear property line. Each of the two variances will require separate motions, and Ms. Richmond is in attendance to answer any questions that you may have, and I'll be happy to answer any questions as well.
All right. Thank you, Mr. Blomley. Questions for Mr. Blomley? All right. Thank you, Mr. Blomley. Ms. Richmond, anything you'd like to add to your application? All right. Then at this time, we'll conduct a public hearing. Anyone present wishing to speak for or against the application, if you would, please come forward. And seeing none, we'll declare the public hearing closed and open the floor for further discussions or a motion. And again, as Mr. Blomley indicated, we need to take this in two separate motions. I guess we'll first consider the request for a variance from Chart 2. And that would be the 10-foot variance to the minimum required 25-foot rear building setback.
Chairman Rogers, I make a motion that we approve, subject to all staff comments.
Second.
We have a motion and a second. Any further discussion? If not, all in favor say aye.
Aye.
Any opposed? All right. Now we'll consider the request for the 3/4 of a foot variance to the minimum required 25-foot rear building setback.
I'll make a motion we approve the 3/4 of a foot setback variance, subject to staff comments.
I'll second.
Motion and a second. Any further discussion? If not, all in favor say aye.
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 Any opposed? All right, Ms. Richmond, that application has been granted. Thank you. All right, we will now move on to special use permit amendment request. This is application Z11059 by Ms. Elizabeth Sharp, requesting an amendment to a special use permit originally approved on February 14, 1996, allowing the establishment of a home-based business, which was a beauty shop at 1803 Leaf Avenue. The subject property is located in a residential single-family RS-15 zone, and the applicant wishes to amend the original special use permit in order to change several aspects of the approved use, including increasing the days and hours of operation for the business, as well as the total number of hours she's allowed to operate her business per week. All right, Mr. Blomley, if you'd review that for us, please.
Yes, sir. Thank you, Chairman Rogers. As you mentioned, this is a special use permit amendment request to a special use permit that was originally granted on February 14th, 1996, allowing the establishment of a home-based business, a beauty shop at 1803 Leaf Avenue. This is at the very northern end of Leaf Avenue, on the west side of Leaf Avenue. The property is zoned RS-15, residential single-family, and is surrounded by single-family residential uses to the south and directly to the north. However, a little bit further to the north is East Northfield Boulevard, where there are some commercial uses and some multifamily uses. And you can see on the aerial photo here, let's see, just to kind of orient you to its proximity. Here's the northern cul-de-sac of Leaf Avenue. Here is Mrs. Sharp's property here, and here is an apartment complex to the rear of it on East Northfield Boulevard, and there's a small strip center along East Northfield Boulevard there as well. Back in 1996, as I mentioned, Ms. Sharp was approved for a home-based business, a beauty shop, and there were specific standards put on her approval. And one of the things that I've included in your agenda materials is the approval letter drafted by Mr. Mike Lilly, who used to be with the city and was the staff advisor to the Board of Zoning Appeals back in 1996. And I'll read that for you because it has the conditions that are applicable that Ms. Sharp is requesting a variance on. It says, "Dear Ms. Sharp, please be advised that at its regular meeting held on February 14th, 1996, the Board of Zoning Appeals granted your request for a special use permit in order to conduct a home occupation, a part-time beauty shop, in a residential single-family RS-15 zone at the above referenced location. The special use permit was granted under the condition that you adhere to the manner of operation you proposed in your letter of intent, specifically that you will operate your business on an appointment-only basis approximately 25 hours per week from 10 a.m. until 4 p.m., Wednesdays through Saturdays. There will be no other employees or operators, and a turnaround area will be provided on site." I had received a phone call from a neighbor who said that Ms. Sharp was operating outside of her days and hours of operation. So I drove by the property and actually talked to Ms. Sharp while I was out at the property. And Ms. Sharp did say that she was seeing customers not in compliance with the 1996 approval. So subsequently, after that time, I met with Ms. Sharp and described to her what she would have to do to make application for a special use permit amendment in order to seek a change to that original special use permit and the conditions thereof. I then sent a letter to Ms. Sharp and restated what we went over in the meeting, and of course reiterated the fact that she, until such time as an amendment to the special use permit was approved, she could not operate outside of the hours and days of operation that she was approved back in 1996. I have continued to get complaints, but I have not observed. I've only observed on one occasion that where I believe Ms. Sharp had a client that I saw at her property at quarter till 10 on a morning of her on a morning of one of the days of operation that she was approved for. However, so to my knowledge or to my observation, I have not. Other than that, I have not seen any violation since she was notified in writing by the planning department. And after the letter went out to her, she then made application to the Board of Zoning Appeals for an amendment to her special use permit. And the three primary areas that she is requesting an amendment to are the number of hours that she is allowed to work per week. The 1996 application specified that she was to work 25 hours a week, or in essence that the beauty salon could be operated for 25 hours per week. She is requesting to increase that number to 50. And the days of operation, as I mentioned, that were approved in 1996 were from 10 a.m. until 4 p.m. on Wednesdays through Saturdays. She's requesting the ability to work from 8 a.m. until 8 p.m. on Mondays through Saturdays. So she's adding Monday and Tuesday and increasing the hours of operation from 10 to 4 to 8 to 8 on those 6 days of the week. Now, one of the questions that you may have is, well, 6 times 12 is 72, 12 hours per day, 8 to 8, times 6 days a week. What she is requesting and what she has included in her write-up is that she be allowed the flexibility to work a 50-hour work week from her beauty shop during those 72 possible hours of operation. Those things requested to be changing. The other aspects of the business that were approved in 1996 are not being requested to change. According to the calculations provided by the applicant, the existing business takes up approximately 235 square feet, or approximately 12% of the square footage of the house. She's not looking to enlarge the workspace. In addition, there are no changes proposed to the existing entrance into the beauty shop, which is on the south side of the house. The applicant does not have any outside employees, nor does she propose to add any outside employees. She was required in 1996 by the BZA to add a turnaround off of her existing driveway in order to accommodate customer parking, and this turnaround appears to be adequate to serve her customers. Ms. Sharp's business was required by the BZA in 1996 to be on an appointment-only basis. She states in her current application that her business is still by appointment only and that she does not accept walk-in clients. She says that the majority of the time there is only one client at her beauty shop at a time, but there are times when appointments overlap or when friends who are clients of hers may arrive together for their appointments. It appears that in 1996 the BZA did not prohibit there being more than one client there at a time. Finally, there is an existing attached business sign above the entrance into the beauty shop on the south side of the house. The sign is less than 3 square feet and does not appear to be in violation. The applicant is not proposing to alter or add to the existing signage. One of the things I wanted to bring to your attention is that before the meeting, Ms. Sharp gave me correspondence, one from a neighbor and one from a client, I believe. There's a letter from Sherry P. Zazueta, who Ms. Sharp said could not attend the meeting. She's at 1802 Leaf Avenue. And the other one is from Pam Stewart, which I don't believe lives in the area, but is a client. Is that correct? Here's a close-up of her property. So here's her driveway off of Leaf Avenue. Here's the turnaround area that she was required to construct as a part of her 1996 approval. And the salon entrance is actually right here on the south side of the house. Here's a floor plan of the existing house. The driveway and the turnaround, and here's the salon area. Here's the salon area here, as well as a restroom and a utility closet, I believe. And there's a carport at the very end of the driveway, and this is the remainder of the living space of the house. This is the front of the house. So here's the edge of the turnaround area. This is looking at the house to the north. That's the neighbor to the north. And that's the Malibu. I had to get that in one picture. Since you don't get the luxury of seeing my Ford Escort anymore.
That is too bad.
This is the property to the south. And that truck is parked in the turnaround area. And these are some photographs of property across the street on the east side of Leaf Avenue, across from Ms. Sharp's residence. And once again, on the east side of Leaf Avenue. This is the turnaround area. Another view of the turnaround area. This is a new fence that Ms. Sharp has installed along the southern property line. And this is kind of in the same area where the entrance to her salon is. Here's the entrance into the salon. There's that attached sign that I mentioned in my staff comments. And here is the inside of her salon. And with that being said, I'll be happy to answer any questions. Ms. Sharp is here as well if you have any questions for her.
All right, thank you, Mr. Blomley. Any questions for Mr. Blomley? All right, thank you. Ms. Sharp, anything you'd like to add to your application?
Yes, I would. First of all, I want to say thank you to Matthew because he's worked with me through this, and I want to let you all know, on purpose, I did not go outside the law. It was through ignorance. I am a law-abiding citizen. I'm a mother, I'm a grandmother, a wife, and I'm a volunteer. And I took it upon myself to change my days because I volunteer, and I don't know if you know what ASATIA is, but it's an abstinence program that is taught in our school system. And so I volunteer one day a week through the school year, and the teacher, the school I'm in, chose Thursdays. So I took, instead of working Thursday, I started working on Monday. And I am in a class and that I take for my own benefit. And so that kind of started me changing these hours. I honestly did not know that I had to have permission to change my hours or to work overtime. I've always been threatened to be fired for not working overtime. And so I did take it upon myself to do that. And so I hope that the city will forgive me for that, because I do care about our city. I do care about my work ethics. The State Board of Cosmetology inspects me twice a year. My inspections, I have made 100s because I care, and I do try to abide by the rules. And except for one time I did make a 98, and that again was through ignorance of not doing something that I didn't know I was supposed to do. But the reason I'm asking to have this flexibility is so that I can continue to do my volunteer work. I love children, I love our youth, and I believe that I am making a difference in these youth's lives. I have a husband who has not worked in 2 years. And my husband is sick, and he probably won't go back to work. And so I am the sole income. My clientele, because of the economics, a lot of them have gone to work. Some of them are working 2 jobs. A lot of the young folks that I did, all the way from elementary through college, are now teachers in our school system. They don't get out of school until 3 or 3:30. And I'm not asking, because I am not a superhuman being, and I don't like working my life away, but I'm asking for the flexibility so that I can take care of my clients, take care of my husband, still do my volunteer work, and also continue in the education that I do for myself, just for my own benefit. And all of my customers, I built my clientele here over 25 years, have been a hairdresser here in Murfreesboro. They are respectful to this neighborhood. They are respectful to my neighbors, and they care about this community as well. And I have been privileged for 15 years of having a salon and being able to work out of my home. And so I'm just asking that you would consider allowing me to have this flexibility. Thank you.
All right. Thank you, Ms. Sharp. Any questions for Ms. Sharp? All right. Then at this time, we'll conduct a public hearing. Anyone present wishing to speak for or against the application, if you would please come forward, state your name and your address.
My name is Keely Benoit. I don't actually live on Leaf Avenue. My parents own a property on Leaf Avenue, and I live at an adjacent street in the neighborhood. I'm here today to ask that this is not granted, and there are several reasons why I feel the board needs to take this into consideration. The first thing is that it was clearly stated that back in 1996, when this was granted, there were regulations put on Ms. Sharp for operating this business. She just stated that she wasn't aware of those hours, but yet you have the letter, and I'm sure she was provided with one also on that meeting day and that hearing. She has blatantly disregarded any regulation or any guideline that was placed on her for this business. She operates this business at all hours of the day, 7 days a week, at her leisure. It's not in question today whether or not her beauty salon is nice and neat or whether she's a good citizen. The question is about whether or not she has followed these guidelines that have been set forth for her since 1996. Mr. Blumley has only witnessed one occasion. We're not here today because she decided that she wants to change her hours. We're here today because she got caught not operating within those guidelines. The neighbors all observed this. The reason that the fence was put up on her property is because she doesn't want the adjacent neighbors' video surveillance catching her clientele that are there so often. This fence got put up right after the first complaint was made because she was aware that her neighbors installed a video surveillance camera and all of her deviation from her guidelines are caught on tape. Yes, the clientele are respectful of the neighborhood, but what needs to be taken into consideration is that this is a cul-de-sac. This is not just a thoroughfare street. This is a cul-de-sac. I'm a mortgage broker. One of the perks to buying a house in a neighborhood like this is that you want to live on a quiet street. That's why people buy a house on a cul-de-sac. They want their kids to be able to play. They want to be able to walk around the neighborhood. They want peace and quiet. When we looked at the map, we did see that this is near Northfield Boulevard, which is a commercial area, but it's not on Northfield Boulevard, which is a commercial area. This is still a residential neighborhood. It is a cul-de-sac. My children play on this street every day. She brings a lot of traffic down this road. This is not just a small home business that cuts 1 to 2 hairs a day. This lady cuts more hair in a day than Supercuts does. It's not just 1 or 2 clients here and there. This is client pulling in, client pulling in, client pulling out, just all day long. She's very aware of Matthew's hours now. We notice now that I'm sure you get off at 4 or 5 in the afternoon. That's when the clients are rolling in. And they're rolling in till 10 o'clock at night. And this is all hours of the day, every day. And like I said, the fence wasn't put up to protect privacy before all of this came about. It was put up for the fact that there were surveillance cameras installed. That's pretty much all I have to say. But like I said, my children play on this street. I have a 3-year-old and a 10-year-old that like to ride their bikes on this cul-de-sac. And I property manage homes in this area, on this street, at the far end of this street. And when you're granted a home business, it's with the thought that you're running a small home business, not as high volume as what she's running. And like I said, the biggest thing I feel like the board members need to take into consideration is that she hasn't abided by these regulations thus far. She has leisure throughout those operation hours to conduct whatever volunteer work she would like to, and flexibility during the Wednesday through Saturday hours from 10 to 4. And I'm asking that before y'all consider granting this, that you make her have a trial period of time where she has to abide by what was already set forth since 1996. She admitted readily to him that she does not operate during the hours which she should operate. She came forth and admitted that after she knew that she was already caught. He has witnessed it once, but he doesn't live in the neighborhood. Like I said, she's very in tune to the hours of the codes department, and if she's not going to be made to follow these, why do we have a codes department? Because as a citizen, we're supposed to have to abide by the law. And there's nothing that's really been done to maintain that she do that.
All right. Thank you, Ms. Sharp.
My name is Roberta Bowles. I moved here in 2007. I knew Elizabeth before I moved down here. She was a friend of my daughter. I started going to her to do my hair. But I want to ask for your apology, or I want to ask an apology of all you, because I was there the 9:45. But what happens is I pick up 2 people to go with me. Sometimes I run a tad late. She did not start working on us till 10 o'clock. But I picked up 2 other women, one of whom is here, Marguerite Burden, right back there. And I pick her up, and I pick up another lady that has Alzheimer's. She cannot drive herself. So if I run late, I try to leave early so I won't be late to hold her up. She only has a few hours to work, and I want to be there on time. Forgive me if I was early. Thank you.
All right. Thank you, Ms. Bowles. And I'm sorry, ma'am, I know your name is not Ms. Sharp. I was looking down here at my paper and I just read it right off.
Chairman Rogers, my name is Maxine Boyd, and I live at 1706 Leaf, and I'm 2 doors down and across from Elizabeth's shop. My parents came with Elizabeth in 1996 when she came to apply. And my parents moved there in 1991, and I moved there in their house in 2001. And I can honestly say that since she has been made aware of the hours, that she has not worked beyond that. And it seems really strange that we've lived on that street, a lot of people, for 50 years, and we have never, ever had any problems until recently. And we've tried to be neighborly, and we've tried to mind our own business and let others live their lives. Thank you.
Thank you, Ms. Boyd.
Hello, my name is Marguerite Burton, and I've been going to Miss Sharp for many years. She has always been kind and decent. She has never done one thing wrong that I would know of. I also introduced her to some of my family, and they have been going to her for many years. We're all from Indiana, and we all just love her. She does good work. She's a kind Christian person. She does more things for people than I know of anyone else to do such nice things. She has us on Friday, widows. She gives us special privileges to go into her sunroom and have a little bite of lunch before we go home. She helps to cook. She does everything that I would ever want any person, whether it be a beautician or not. And I ask that you respect her, because the things that have been told are untrue. They're untrue, and I would swear to that on Holy Bible. And please do the best for her that you would do for any good person. Thank you.
Thank you, Ms. Burton.
Mr. Chairman, board members, I'm Carlisle King. I live at 1807 Leaf Avenue, right next to Ms. Sharp. And I've lived there for 38 years. And I've known them since 1996. I've never seen anything out of the way. It's always been kindness shown to us. And as far as people coming to her shop, most of the time you'll only see 3 cars parked over there at a time, probably. She works by appointment. And I say this, there's never been anything out of the way done at her shop. This has just started recently, the things that's happening. and I think she should be granted what she's asking for.
Thank you, Mr. Kane.
Hello, Mr. Chairman. My name is Gary Alley. I came today not expecting to speak, but after hearing the anger that's built here, I have to. I'm one of the clients who she cut hair for before college, through college, beyond college, and she's always cut it there. One of the nicest ladies I've ever met, hardest working, and I'd like to ask the board if they know very many people that would come and ask if they could work more. This economy should be considered. Her husband, out of work, won't return to work. He's a great man, has always worked as many hours as he could, and now he can't work. So Miss Sharp needs more income, and what she does doesn't affect anybody and hasn't for years until, as everyone has said, recently. And as far as the video surveillance goes, I would put up a fence myself if I saw someone filming me. I couldn't stand that. I mean, I deserve my privacy as well. So there's another issue itself. But thank you for your time.
All right. Thank you, Mr. Alley.
My name is Gary Weaver, and I live at 1715 Leaf Avenue, right next to Ms. Sharp. I have to say she is a hard worker. She works about 14 hours a day, every day. She has a lot of traffic coming in and out, approximately 50 people a day. So that's about 300 cars a week. That's a lot of traffic for a residential neighborhood. And I put up a home security system. So that's, that's what they're talking about, the video surveillance. It's actually a home security system. And I think she objected to the camera watching her business more than the camera watching her, because she's been operating out of her guidelines for a long time. She operates from 7 o'clock every morning to about 9 o'clock at night. And after Matthew caught her, she changed her hours. She's been having customers a little earlier, sometimes as early as 6. And since zoning only works from 8 to 5, and they don't leave the office till about 9, she's been having customers before and after zoning, so they can catch her. She'll quit having customers in the morning about 8:30, and she won't have any more until 10 o'clock. And her guidelines are from 10 to 4, so she has customers till 4 o'clock. Then she quits at 4. Well, after that, she has customers again at 5:30 till about 9, 10 o'clock, something like that. Well, there's nobody working in zoning that early or that late to ever catch her. So, let's see. Oh, she has a lot of traffic over there. Sometimes there's, like Mr. King says, sometimes there's 3 cars at a time. Sometimes she operates her business kind of different from one day to the next. Some days there'll be like 5 cars. And other days there'll be 3, something like that. I haven't seen as many as 9 cars there at one time. But I don't know. I think there ought to be some kind of guidelines according to how much traffic she can have. And I really object to the nighttime traffic, because all the cars that go in and out, all the headlights flash over our windows, the living room windows and the bedroom windows. And when the people come and go, it sets off all our motion detector lights, and it lights up, our bedroom till 10 o'clock at night. Other than that, I can't think of anything else to say. Other than I don't think she should be granted an extension to double her hours and work late at night.
Thank you,
Okay.
Mr. Weaver.
I'm Doug Cawthorn. I'm not with the city. I was just grabbing a more comfortable chair over there. I live at 2307 Riverview Drive, and I'm a client of Elizabeth Sharp. I have been for 10 plus or minus years. I think what you're seeing today is one source of false complaints, and I think you guys have already done the math on this, but if 50 people are coming to a beauty shop in a day with one operator and a haircut takes 30 minutes, there's not enough hours in the day to have 50 people in this shop. So that's the kind of negative information you're getting. I will tell you that Elizabeth Sharp is the finest citizen in Murfreesboro. She's a great person. She said she's not superhuman, but she's as close as I know to it with all the volunteer work, with the work that she does, and now providing the sole support for her family. So I highly recommend that you grant her petition for a change in hours. She is the sole source for her family. She needs to be able to operate with the flexibility that she's asked for. Thank you.
All right. Thank you, Mr. Cawthorn.
Chairman Rogers, members of the board, my name is David Edwards. I live at 1914 Greenland Drive. And for public record, I would like to state that I was once on the Board of Zoning Appeals, the Planning Committee, and also served Murfreesboro as a city councilman for 4 years earlier in this decade. I was on the Planning Commission when we worked for most of 2 years to revamp and rebuild the home occupation ordinance in Murfreesboro. And I can tell you that during that 2-year period, it was amazing how often the needs changed and how fluid the dynamics were of home occupation. And with that said, I would suggest that today's amendment request of variance is further indication that the city probably needs to revisit the home occupation and continue to adjust as technology has brought more and more business access into the home, and telecommuting has become more standardized. But here we have one woman seeing one client at a time in a very classic configuration. So for those reasons, I would endorse your approving of the request as it was issued. But on another more personal level, like Mr. King, at a period of time almost 20 years ago, I lived on the other side of Mr. and Ms. Sharp in the property that Mr. Gary Weaver, who just spoke ahead of me, owns, and I rented it from him for a period of time. I lived there in 96 and in 95 when first Mrs. Sharp was considering the move of her business to her home as her son Michael got older. And then when she actually began the process of making an application and complying with the city's ordinances, and I believe if the city at that time had requested for Ms. Sharp to stand on her head and whistle the Star-Spangled Banner to comply, she would have been found doing that very thing. So I observed her firsthand as a neighbor. I watched her very legalistic intent to comply. And then since we've moved away, my wife has gotten her hair cut for years and years from Elizabeth. As her work schedule changed and her time became less flexible, she wound up going away. But I went back and inquired with my wife what a typical situation was like in Elizabeth's shop. And she said, well, Generally, you're there alone, and it's a good thing, because if there were more than two of us in there, we'd never get anything done for having so much fun. And I think that speaks to her congenial nature and to her caring about people. So the anecdotal information that's been stated here today about dozens and dozens and scores of people working their way through this little 232 feet office or shop is simply not true. I do not know anything about Elizabeth's financial condition, but I know a lot about auditing financial records, and I dare say if we look at her if we look at her tax records and her income as far as what she deposits, it verifies the number of clients that she is contending that she serves in a month and a year as well. So for all of these reasons, and we won't even get into the hardships of her husband's sickness and her being the sole provider or a downturn in the economy, but just based on these other reasons, I would suggest strongly that you consider recommending as requested.
All right. Thank you, Mr. Edwards. Ms. Sharp, let me make sure there's no one else that needs to speak before I let you speak again. Anyone else wishing to speak for or against the application? Okay, Ms. Sharp.
I just want to make a clarification of a few things. Every car that is in and out of my driveway is not a client. I do have children, and I have grandchildren. I have friends, and I have sisters in Christ. I have a Bible study every Tuesday night. 2 of them, as a matter of fact, one from 4:30 to 5:30, one from 6 to 7. And those cars that are in my driveway at that time, those are people who are coming for me to teach them the Word of God or for us to teach each other. And I do have people that I minister to who are cancer patients that come for prayer, that come to be encouraged. And so my home is busy, but my home is separate from my business. And I just wanted to make that clarification. And when all this came about, the lady that spoke about getting there 15 minutes early, she was sitting out in the driveway, and my husband, I was in the house preparing things, and he let her in because she needed to go to the bathroom. And so the flexibility to me is important. I mean, you know, when something happens, maybe a customer's late, maybe they're in traffic or whatever reason, and they come in late. And it puts me 10, 15 minutes behind. And I have a customer with color on her hair. Am I supposed to say, okay, I got to punch the clock and you got to go home? And so that's where some of that flexibility comes into of me asking also, because of, you know, when someone comes in early, do I just say, well, the door's locked and I'll just sit here with you and we'll just wait till you go in. But I did want to clarify about when there's 4, 5, 6 cars in my driveway and they're pulled up in the driveway, that's usually my Bible study class that's coming, and we're sitting in our sunroom there. So thank you.
Thank you, Ms. Sharp. At this time, we'll close the public hearing and open the floor for further discussions or motion. Or questions?
I'll start with a comment. I think any time that you have a business in a neighborhood, first off, whether bad times or good times, we need to try to accommodate the people that are living in the neighborhood. Number one, I think you need to, in any neighborhood, we need to try to keep the integrity of the residential zoning. Of course, as David or Mr. Edwards mentioned, that's why there is residential occupation businesses allowed. That's why that come before this board to try to, I wouldn't say limit those businesses, but I would say I think the purpose in this board and giving a ruling is trying to make sure that, the integrity of that neighborhood is kept. I don't have any problem with this type of business being in a neighborhood, especially it sounds like we're getting differing opinions, but that you've got people there one at a time. I don't necessarily have a problem with the Monday through Saturday because there's been other approvals that we have had either 5 to 6 days a week with respects to a beauty salon in a home. The one negative comment that I will make is, in two parts. Number one is I'm not sure that I would be personally in a position to allow it to be 8 to 8. I do think that, in my opinion, you are hinging on the integrity of residential versus commercial when you get past 6 o'clock. So that would be my one recommendation. The other thing is and I couldn't grasp exactly other than we were trying to accomplish by having this 72-hour span, but saying we're only going to use 50 hours. I don't know how you gauge that. And so I don't think that it becomes a flexibility issue. In my view, it's just you deal with the set times, and that's what we deal with. And if you happen to have somebody there from 8 to 6, more power to you. And if you don't, that's your choice. But I don't see where we can say have it 8 to 8, 72 hours, but you're going to only use 50. I don't know practically how that would work. But that's just my 2 cents worth at this point.
I'm generally, I don't know that we're lockstep, but we're pretty close. I just think 12 hours a day, 6 days a week, just I'm not sure there's many commercial businesses that run that many hours that are in strip malls. I mean, I don't have any problem necessarily with Saturday hours, but when coupled with going 8 to 8, 5 days a week, I just think it's too. It just smacks of a business, and it's a home occupation business. There's a slash there. In the approval before, it gave you some days off and sometimes on, and limited your hours, which balanced those two things. But I don't. In your application, I frankly don't see a balance except for Sunday. I mean, 8 to 8 and 6 days a week. I don't know what offsets the balance between home and business. And I understand you want flexibility to do that, but I also agree, I don't know how the city, unless we just post somebody outside your door with a stopwatch, I don't know how we actually can regulate the fact that you're going to not use all of those hours. I mean, basically, if we approve it, I think we have to assume you're going to be running customers from 8 to 8. Because there's no practical way to regulate that or to know that. So, I mean, I'm not unsympathetic to what you're trying to do. There's always this balance on earning a living, but having a right to earn a living at home versus going out and, opening up a storefront and going into those is where we get this balance. And this just looks like a storefront, 8 to 8, 6 days a week to me. So, and based on this application, I don't think I could support the application as presented.
My thoughts as it was being presented was along Mr. Halliburton's, and that 8 o'clock at night in a residential areas can be kind of tough. I was thinking 6 o'clock happened to be the number I came up with, but kind of, that's along the lines I'm thinking that I would be okay with.
I agree with the others. I mean, I think she's doing a wonderful job, and I'm so impressed with it, but we as a board, have to represent what the ordinance are. That's the only thing. We have to do that. And I was thinking, maybe we could adjust it to 8 to 5. And if she would be satisfied with that time, instead of 10 to 4.
I agree with all those comments. I couldn't have said it better myself, so I won't.
I mean, I'll go ahead and make an we can make a motion to amend the times, can we not, as part of our approval, or is it something that she would need to resubmit based upon her wanting to do that?
No, you can make change as long as you're not increasing the hours and days of operation. Then you brought up something about that number of hours worked per week as something that would be difficult to enforce. And I think she included that in there because in the original approval, for some reason, one of the conditions was a 25-hour-a-week work week. But I agree with you. That's a very, very difficult thing to enforce. And I agree with you that the hours of operation are easier to enforce than total number of hours of operation. And I wonder if, and I might get Mr. Ives' opinion on this, if that aspect of the original approval was for a 25-hour work week. She's requested a 50-hour work week in the context of those hours of operation. The aspect of the total number of hours worked per week, is that something that can the board look at just hours and days of operation?
Yes, I believe a motion setting a number of, or a starting time and an ending time without regard to the actual number of clients or number of hours she works a week would be appropriate. That answer your question, Matthew?
Yes, thank you, Mr. Ives.
Just a point of clarification, when you mentioned number of clients, the only aspects of the original approval we would be changing would be the hours. So the requirement that they all be by appointment would still be not affecting any of those previous requirements.
Correct.
That's correct. What really the only changes were the days of operation, the hours of operation, and the total number of hours worked. And all three of those elements of the home-based business were explicitly part of the approval in 1996. All other things would remain the same. The facilities themselves are not proposed to be changed. The signage is not proposed to be changed. No additional employees are proposed. The situation as far as where customers park is not proposed to change. Those aspects that I outlined first are what she is looking to amend.
I don't know what y'all are thinking about for amendment. From my perspective, I think the most that I could consider voting for would be 5 days a week, 8 hours a day. I think if you get beyond operating hours of 40 hours a week, that's my personal take on it. I don't know what anybody's motion is going to look like, but I don't know if you get into 6 days or more than 8 hours a day. I just think you're into having a storefront.
Well, the reason I said 8 to 5 was because I felt like you know, that, I know that's like 9 hours, but you got to have a lunch break.
Yeah, I get
So,
that. I'm
I was just-
yeah, I understand what you're saying.
Well, I'll make a motion that's in the middle. How about this? And we'll see where it goes. I'll make a motion that we approve this application with the exception of the times and hours that have been requested. And I'll make a motion that we limit the hours of operation from 8 a.m. to 5 p.m. However, still have it Monday through Saturday.
I'll second that motion.
All right, we have a motion and a second to further discussion.
May I ask for a point of clarification? Would that be to disregard any maximum number of hours per week?
Correct.
So
Yes.
everything within those hours of operation would be acceptable? Is that part of the motion?
Yes.
Okay.
And so I would point out that, and I'm not saying this is bad, I'm just observing that she's going from a maximum of 25 hours per week from 1996 to 54 hours per week under this schedule. True? Okay. So it's actually a little bit, that's actually more than what she's applied for, Matthew, isn't it? Because she's only applied for a maximum of 50 hours per week.
But that assumes that you're able to book an appointment either every half hour on the half hour or every hour, whatever it is, and you can actually fill those up. I mean, it is one thing to open up a store for a given period of time and you're there, and when you're working by appointment, and I don't say this to argue the motion or anything else, but when you're looking at maximum hours, reality is it's probably difficult to fill all day, even if you wanted to fill all day, every day with appointments.
I guess where I'm going, though, is did we advertise this correctly? Because are we short now? We're going to grant 50, the motion is to grant 54 hours. The application was just for 50 hours.
She asked for 12 hours a day,
72
6
hours.
days a week. She asked for 72 hours of operating hours.
Well, it said in the notes, it says she would like to work a maximum of 50 hours
But
per week.
she
I
wanted
guess
to
that's
pick
right.
her hours within the 72, but we're not,
Which-
as I understand the
not-
motion, it's to remove any limitation on maximum hours worked and just give her the parameters of beginning and ending.
Was the maximum hours, number of hours per week included in the ad?
The ad read like the agenda read, which says that application Z11059 by Ms. M. Elizabeth Sharp is requesting an amendment to a special use permit originally approved on February 14th, 1996, allowing the establishment of a home-based business, a beauty shop at 1803 Leaf Avenue.
Okay.
The subject property is located in a residential single-family RS-15 zone. The applicant wishes to amend the original special use permit in order to change several aspects of the approved use, including increasing the days and hours of operation for the business, as well as the total number of hours she is allowed to operate her business per week.
Okay, so it doesn't specify a number of hours.
No, and let me verify that. Get the file and just verify that the wording was the same on the legal notice.
Yeah. Yes.
The legal notice read exactly the same as the agenda did. It didn't, the legal notice did not include the specific hours and days and total number of hours. It just said that it was, her request was to increase the days and hours of operation for the business as well as the total number of hours she is allowed to operate her business per week. and Mr. Ives may wish to comment on whether or not, if you approve the motion as, which 9 times 6 is 54, if that would be acceptable based on the wording of the legal notice.
I believe that it would be.
Okay. Okay. I said it wasn't bad. After calculating those number of hours, she's actually that would be more than what she's even asked for. So I'm probably going to on this one probably vote against that particular motion. I think decide with Mr. Dodd on that one. I probably would maybe cut a day out of there, Tuesday through Saturday, just to drop. That would drop it down to 45 hours, which is an increase from 25 to 45, so a pretty significant increase, almost double. Okay. Anyway, any more discussion? All right. All in favor say aye.
Aye.
Any opposed? No. Okay. I think, Ms. Mosby, did you?
She seconded it, yes.
Okay. Okay. So that motion then passed, vote of 3-2.
Chairman Rogers, could we get a roll call vote on that?
Okay. Do a roll call.
Adam Dodd,
No.
Kenny Halliburton,
Yes.
John Rogers,
No.
Davis Young,
Yes.
and Francis Mosby.
Yes.
Okay. Ms. Sharp, your application has been granted, subject to the provision that you are allowed to operate between the hours of 8 a.m. and 5 p.m. Monday through Saturday. Agreed?
I will be in school teaching one of those days a week at Christiana Middle. I teach all day.
Very good. Thank you. Appreciate everyone being here today. Do we need to take a break? Y'all want?
I could use a quick one.
Yeah. Okay. We're gonna adjourn for about 5 minutes and be right back. All right, we are back in.
Oh, it's on there.
We are back in session, and we'll now consider application Z 11060 by Mr. Salvatore Vasile, requesting a special use permit in order to construct an accessory apartment in a residential single-family RS-12 zone. And this is for property located at 1914 Bridget Drive. Mr. Blomley.
Thank you, Chairman Rogers. As you mentioned, the subject property is located at 1914 Bridget Drive, which is located at the northeast corner of Bridget Drive and Sulphur Springs Road in the Thompson Square subdivision. And I'll show you an aerial photograph now. Here is Mr. Vasile's house. You'll notice that the lot is quite large. That's his property that goes all the way to Sulphur Springs Road. The majority of his property is a large drainage easement, and the same with the property along the south side of Bridget Drive. It looks like the one on the south side has a baseball field, and I believe Mr. Vasile's property has a soccer field. So those areas, because of the drainage easement, no structures can be built in those areas. The drainage easement actually begins just near the edge of Mr. Vasile's driveway and does extend all the way to Sulphur Springs Road. Mr. Vasile has made a request for an accessory apartment. In his application, he has written that his mother-in-law is proposed to occupy the accessory apartment, and he wants the ability to have a full kitchen in there as opposed to just a bedroom and living space that would occupy the rest of the house, which would be considered part of the main dwelling unit. But this dwelling unit would contain all of the elements of a standalone dwelling unit, including full bathroom, full kitchen, living room, and 2 bedrooms. The 1 bedroom would actually be used as a bedroom, and the other bedroom would be used as a chapel room, as he calls it, for his mother-in-law. What Mr. Vasile is requesting to do is to build an addition onto the west side of his house. You'll see on the aerial photo, here is his house, and what he is looking to do is, near the back edge of his driveway, extend his house to the west, and there would be a 1-car garage which would be used for Mr. Vasile's family. His mother-in-law, I believe, does not drive, so the rest of the addition, which would be a 1-story addition, would be used as her accessory apartment. It would be approximately 630 square feet. The maximum, as you know, as dictated by the zoning ordinance, that the maximum size of an accessory apartment is 700 square feet. So he's within the maximum size requirements. You have the larger site plan in front of you. You'll see the boundary of the drainage easement. You'll notice that the site plan calls out the drainage easement on the property. You'll notice that it says the distance to the drainage easement is 23.8 feet, and the addition would go out from that back corner of the house 23.4 feet. Mr. Vasile included a hand-drawn floor plan, and you'll see here is the 1-car garage that will be used as would be used by he and his family. The 1-car garage will access the main house, and even though there is no door shown from the accessory apartment to the main house, as you know, one of the standards is that the accessory apartment, if it was ever discontinued, would have to be able to be used as a part of the main house. And so Mr. Vasile said that he had intended to draw a door leading from the living room of the accessory apartment into the garage so that people could walk between the accessory apartment and through the garage into the main house. But he said he neglected to do that, but he did mean to include a door from the accessory apartment into the new 1-car garage. But as you can see, as I mentioned, the 1-car garage here, living room here, kitchen area here, bathroom, the main bedroom, and the chapel room, which he has labeled as bedroom number 2. Now, elevations are not required, but I asked Mr. Vasili to try his hand at showing you what the addition was going to look like. Right now, the existing house is a mixture of brick and with some vinyl siding. This is just an approximate representation of how it would look. This would be, in front of this would be the existing driveway. You'll see a one-car garage, which would be half of the front of the addition, and then that would be the window of the living room of the accessory apartment. The door would actually be on the side of the house facing Sulphur Springs Road, which is a significant distance away from Sulphur Springs Road. This kind of makes it look like it's 2 stories, but it's not 2 stories. The door here would be on this front corner of the house. This view of the house would be what you would see facing Sulphur Springs Road, which, as I mentioned, is a good distance away. So in order to keep the front of the house as it faces Bridget Drive looking still like a single-family residence, and to meet the intent of the zoning ordinance, Mr. Vasili has put the front door into the accessory apartment on the side of the house. And even though it faces a public street, it's a significant distance away from the public street of Sulphur Springs Road. The applicant has mentioned in his materials that this accessory apartment would be for his mother-in-law, and Mr. Vasili and his wife would be the primary caretakers. They understand that it cannot be rented out to non-family members, and that if the board sees fit to condition it upon a deed restriction being recorded, that it meet the requirements of the zoning ordinance with regards to who can occupy it, he would be willing to have that recorded. The addition will be compliant with all setback requirements and is not shown to encroach into that drainage easement. As I mentioned, the accessory apartment would be compliant with the maximum 700 square foot size requirement. If the board desires to approve this request, staff recommends the following conditions. And one thing that I'll point out to you is that I put a revised list of conditions on your table. That I added a 4th condition, and that would be recommended conditions of approval for BZA case ZI 11060, revised October 26, 2011. The 4th condition is something that would be required during the building permit stage, and it would be required really whether it's made a condition or not, but I think it was good to get it on the record because it is in a sensitive drainage area. And I'll read that 4th condition. The proposed addition must comply with the minimum pad and minimum floor elevation requirements listed on the recorded plat, Thompson Square, Section 5, for this lot. And then I'll read the other 3 recommended conditions of approval. Number 1, a deed restriction must be recorded stating that the accessory apartment will not be used for rental purposes and that it will comply with all the standards specified in the zoning ordinance. That's the standard condition that the board places on approval of accessory apartments. Number 2, a surveyor will be required to help lay out the footing of the building addition, and a surveyor's certification must be provided that the building addition does not encroach into that drainage easement. It's getting very dangerously close to encroaching into that drainage easement. There's about 4/10 of a foot left to spare, and we just want to make sure that that structure does not end up encroaching into that drainage easement. And getting a surveyor involved in the process, which Mr. Vasili has already done by having the survey drawn, the plot plan drawn up, will help to ensure that the addition does not encroach into that easement. Number 3, the accessory apartment must be able to internally access the existing house. To this end, there must be a door from the accessory apartment into the new 1-car garage and a door from the new 1-car garage into the existing house. That would help ensure that there is, at all times, will be access from the accessory apartment to the main house, so that if it ever did discontinue being an accessory apartment, that it could be allowed to be used in conjunction with the main part of the house as a part of the living area of the main part of the house. Now I'll show you some photographs of the site. This is the front of Mr. Vasili's house. as it faces Bridget Drive. This is the side of Mr. Vasili's house facing Sulphur Springs Road. The addition would begin right in between the existing two-car garage and this door. So that door would still remain, and that would be what gains access from the one-car garage into the main house. So the addition will actually go back and extend out from this back corner of the house up to this area here. This is just a view of the backyard behind where the addition will be built. And this is just another view of where the addition will be built, looking back down the driveway towards Bridget Drive. That's a view of part of the drainage easement and the neighboring property to the north, which is a large residential lot in the unincorporated county. Now, I mentioned the soccer field earlier. This is looking from Mr. Vasili's driveway all the way to Sulphur Springs Road. You see it's quite a distance to Sulphur Springs Road because all of this is a low-lying drainage easement. This is the lot across the street that is also large and extends all the way to Sulphur Springs Road. And just some of the neighboring properties. The house directly across the street. It's looking down Bridget Drive on the south side of the street. And this is looking down Bridget Drive on the north side of the street. With that being said, I'll be happy to answer any questions. Mr. Vasili is in attendance if you have any questions for him as well.
All right. Thank you, Mr. Blomley. Questions for Mr. Blomley?
Only that door that you showed where it was going to connect up with the house, does that go into the existing garage? That's a man door for that garage?
I believe so. Is that correct, Mr. Vasili?
Yes.
He
So
said
there's going to be
yes.
a door from the new structure's dwelling area to a one-car garage, which will be attached to a door that goes into the attached garage that then goes in the house.
That's correct.
And that's sufficient for our requirement about it. It's just got to have access through there.
That would be my interpretation. It's because garage space could always be converted into living space, and so one day that may end up being just that one-car garage may end up being living space or a bonus room if they chose to convert it to living space from a garage.
Matthew, you mentioned it earlier. One of the general conditions we place on this, in addition to the fact that it will not be used for rental purposes, that it would only be used by family members. Am I right in remembering that?
What the zoning ordinance says is that it can be used by family members, which is his stated purpose, which would be his mother-in-law.
So, I guess my question is the family part of it's covered under the standard zoning ordinance, right?
Yes.
Okay.
It says that it can be family members or invited guests, and we interpret that to mean short-term invited guests. So it would be like, say down the road, if his mother-in-law was not living there and he was having out-of-town family or friends, they would be allowed to stay in the accessory apartment. But at no time could it be used as a rental unit to non-family members.
Okay. Yeah, questions for Mr. Blomley? All right, Mr. Vasili, is there anything you'd like to add to the application? And at this time, we'll conduct a public hearing. Anyone present wishing to speak for or against this application, if you would, please come forward. And seeing none, we'll declare the public hearing closed and open the floor for any further discussions or motion.
Mr. Chairman, I'll make a motion we approve the application subject to the 4 staff comments.
One second.
All right, we have a motion and a second. Any further discussion? If not, all in favor say aye.
Aye.
Any opposed? All right, Mr. Vasili, that application has been granted. Appreciate your patience today. I know it's been a long day. Give us an A for entertainment, right? All right, next we'll move on to application Z11061 by Mr. Dan Ongst for Boy Scout Troop 197, Fellowship United Methodist Church. They are requesting a special use permit in order to operate a temporary outdoor vending establishment, which would be Christmas tree sales, at an institutional group assembly use, which would be a place of worship, in a residential single-family RS-15 zone. And this is for property located at 2511 New Salem Highway. Mr. Blomley.
Thank you, Chairman Rogers. This is an application that we've seen the past 3 years. If you recall, about 3 years ago, the Planning Commission and the City Council adopted an amendment to the zoning ordinance which allowed institutional group assembly uses to have Christmas tree sales as an accessory use to the institutional group assembly use. Boy Scout Troop number 197 is a ministry of Fellowship United Methodist Church. And for the past 3 years, they have made application to the Board of Zoning Appeals to sell Christmas trees at the church property. And they intend on doing the same thing this year. The setup will essentially be the same. The site has passed its initial codes and zoning inspections, and to my knowledge, we have not received any complaints. I think there may have been some issues with signage in the past, but we'll make sure that any signage on the site will comply with minimum requirements. With that being said, the time frame with which the applicant is requesting to operate falls within the guidelines for Christmas tree sales, and he appears to meet all of the other requirements for temporary vending. If the board approves this application, staff recommends the following conditions. The site must pass an electrical safety inspection prior to opening for business. An electrical permit must be purchased from the Building and Codes Department in order to obtain this inspection. And number two, the tent must meet all minimum building setback requirements for the RS-15 zoning district. And I'll just show you a quick aerial photo of the property. The location of the sales area will be in the same place that it's been for the last 3 years. It's this area here in the western parking lot. The Christmas trees are set up in this area, and parking occurs in the surrounding area. And it's not operated during peak hours for the church, i.e. Sunday morning, and there's ample parking out there to accommodate the use. And you'll see here's the setup here. This area would be the sales area. There would be two small tents here on the corner of the parking lot, and there's a supply trailer that they leave on site with their supplies in it that would be parked in one of the parking spaces. And there's a fire hydrant, I believe within 200 feet adjacent to the building of the sales area. With that being said, I'll be happy to answer any questions, and Mr. Ongst is here if you have any questions for him as well.
All right, thank you, Mr. Blomley. Questions for Mr. Blomley? No, Mr. Ongst, anything you'd like to add to your application?
I just want to let Matt know that I'm also going to apply to open up a hair salon and a firecracker station there too, okay?
Your chances of this application being granted just went down substantially. All right, at this time we'll conduct a public hearing. Anyone present wishing to speak for or against the application, if you would, please come forward. And seeing none, we'll declare the public hearing closed and open the floor for further discussions or motion.
Chairman Rogers, I make a motion we approve, subject to any staff comments.
Second.
All right, a motion and a second. Any further discussion? If not, all in favor say aye.
Aye.
Any opposed? All right, Mr. Ongst, you have been granted that application again.
No.
No hair salon. All right, thank you. Appreciate you coming in. Always good to see you. All right, application Z11062 by Mr. Mike Jones for the North Boulevard Church of Christ Men's Ministry, requesting a special use permit in order to operate a temporary Christmas tree sales in a commercial highway zone. And this is for property located at 1266 Northwest Broad Street. Mr. Blomley.
Thank you, Chairman Rogers. This is, like the last one, is an application that we've seen for a number of years. Mr. Jones, however, the difference between the two is that Mr. Onk's request was at an institutional group assembly use. This is a traditional temporary vendor use at a commercial location. The applicant has been approved for this location for the last 5 years before the Board of Zoning Appeals, and he is requesting to sell Christmas trees within the allowed time frame in the zoning ordinance. The site passed its initial codes and zoning inspections, and to my knowledge, we have not received any complaints about the operation of this site in past years. The site, I guess I forgot to describe the location of the site, but I think all of us are familiar with it. It's this grassy area here along West Clark Boulevard at the Kmart Shopping Center. The applicant will usually puts up a small building on the property for shelter during inclement weather, an 8x8 building, and the Christmas trees are all displayed on that grassy area behind the 42-foot front setback line. And there appears to be ample parking, and I've never had any complaints regarding parking on this site. With that being said, if approved, staff recommends the following conditions. The site must pass an electrical safety inspection prior to opening for business. An electrical permit must be purchased from the Building and Codes Department in order to obtain this inspection. And number 2, the 8x8 portable building must comply with the minimum required 42-foot front building setback. Mr. Jones is in attendance if you have any questions for him. If you have any questions for me, I'll be happy to answer them also.
All right. Thank you, Mr. Blomley. Questions for Mr. Blomley? Mr. Jones, anything you'd like to add to your application? This time, then, we'll conduct a public hearing. Anyone present wishing to speak for or against the application, if you would, please come forward. And seeing none, we'll declare the public hearing closed and open the floor for further discussions or motion.
Mr. Chairman, I'll make a motion to approve the application with the recommendations of the conditions set by the staff.
I'll second.
We have a motion and a second. Any further discussion? Not all in favor, say aye.
Aye.
Aye. Any opposed? All right. Mr. Jones, that application has been granted. Appreciate your patience with us today. All right, and finally, we have application Z11063 by Mr. Jim McLeod for Santa's Trees, requesting a special use permit in order to operate a temporary Christmas tree sales establishment in a commercial highway zone, and this is for property located at the northeast corner of Memorial Boulevard and Airport Road. Mr. Blomley.
Thank you, Chairman Rogers. The site, as you mentioned, is at the northeast corner of Memorial Boulevard and Airport Road. This site has been approved in the past for seasonal Christmas tree sales, but it's been several years since anybody's made application for Christmas tree sales at this location. I believe it was probably in either 2007 or 2008 since we received the last application for this location. Despite that fact, the subject property has been approved for temporary vending in years past. As we all know, this is a site that Mid-America annually has approved for fireworks sales, and they typically will make application for both the July 4th and New Year's timeframes. Earlier this year, Mid-America was approved for both the July 4th and New Year's timeframes for this site. Mr. McLeod has made application to sell and to work kind of in conjunction with Mr. Lloyd at Mid-America, and so that they could share some of the same items, such as the source of electricity and the tent that both of them will be using. One of the differences between what we see submitted annually on the fireworks sales and what Mr. McLeod has submitted is that Mr. McLeod will actually be using part of the lot to the north. Mr. Lloyd usually keeps his operation contained within the gravel area, which is on the property directly on the corner of Memorial and Airport. And I'll show you the site plan in a moment, but Mr. McLeod's, some of the Christmas tree inventory will actually spill onto the lot next door. Both of those lots are owned by the Huddleston family, and Mr. McLeod has submitted a letter from Henry Huddleston granting him permission to use the Huddleston's property. One of the neat things about Mr. McLeod's application is he works in computers in addition to selling Christmas trees, and so he had some pretty neat 3D renderings that I wanted to show to you. planning on using a 30 by 60 tent, and this is as if we were looking down from the air, looking kind of northeast. And the Christmas tree inventory would be to the north of the tent. The tent would be at the edge of the gravel area, just like it normally is. There would be some inventory to the rear of the tent and also to the north of the tent. But he would maintain all the inventory and the tent outside of the 42-foot front setback. And this is a view of the tent looking to the southeast. Now, his actual site plan and you'll see the 30 by 60 tent. One of the things that I brought up in my staff comments was that tent is substantially smaller than the tent that Mid-America was approved for. However, they typically use a smaller tent during the New Year's selling season because the volume that they do is a lot less. So I did receive confirmation from Mid-America that they are going to use the same size tent, and as a matter of fact, the exact same tent that Santa's Trees will be using on this lot. And you'll see here how the inventory area is along the edge of the gravel area here and extends to the north of the tent itself. And while some of the tree inventory will be located on the gravel, as I showed you on that site plan, on the eastern edge of that gravel, Mr. McLeod has indicated that the traffic for a Christmas tree lot is a lot different from the traffic for a fireworks tent. Christmas tree lot, the traffic usually trickles in, but on a consistent basis. It's my understanding that on seasonal fireworks tents, with the exception of the day or two leading up to July 4th or New Year's, it's pretty stagnant. But on the day or two leading up to New Year's and July 4th and on the holidays themselves, the volume of vehicles going into the site is very high. Well, Mr. McLeod says the number of vehicles that will be on this site at one time will not be as great as the peak times for the fireworks. It will be more steady, but throughout the entire selling season. Mr. McLeod proposes to begin operating on November the 15th and November the 21st through December the 21st. And as I mentioned, he will kind of work with Mr. Lloyd to the transition between the two vendors, so there's enough time for Mr. Lloyd to get set up before his dates of operation are allowed to proceed. Because in order for that to work, Mr. McLeod will need to pass his cleanup inspection before Mr. Lloyd can get his permits. And being that Mr. Lloyd has already been approved for his special use permit, we want to make sure that those two temporary vending operations, kind of their schedules dovetail. One of the concerns that our city traffic engineer discussed, and that I've also discussed with Mr. McLeod, is that there are actually two ramps. If we could bring the aerial photo up, there are several ramps in front of the Christmas tree inventory. And typically in the past, the temporary vending operations have not spilled onto the lot to the north. What we want to avoid is having traffic enter in on these existing ramps on Memorial Boulevard and park in the grass or access the gravel in front of the trees. We want the traffic to continue to be able to use the existing gravel access points on both Airport and Memorial. And so what Mr. Balachandra, our city traffic engineer, has recommended, and what I put in the staff comments, is that those areas be barricaded with cones, and also that there be some type of perimeter fencing along the front of the inventory facing Memorial Boulevard. And that will kind of help delineate what area is for pedestrians and what area is for vehicles. And the area that will be for vehicles will be the gravel area. If approved, staff recommends the following conditions. The site must pass an electrical safety inspection prior to opening for business. An electrical permit must be purchased from the Building and Codes Department in order to obtain this inspection. Number 2, the tent must comply with the minimum 42-foot front setback requirement, and a tent permit must be purchased from the Building and Codes Department. In both of the previous 2 applications, the pop-up tents and the small structure that the Kmart were not large enough to cross the threshold into requiring a permit. Mr. McLeod says that the 30 by 60 tent that he will be used for checkout, for the retail sale of other holiday items like wreaths and garland, things like that, and also for storage of additional inventory. Number 3, per the recommendations of the city traffic engineer, the existing ramps along Memorial Boulevard must be coned off to discourage motorists from entering the site at these locations. In addition, a barrier must be placed in front of the Christmas tree inventory display, such as construction fencing, and appropriate directional signage must be used to direct patrons to use the correct ramps into the gravel parking area. And number 4, there can be no weeds or grass growing up through the parking lot or in the area where the tent is proposed to be located. Mr. McLeod and his team will need to work on that a little bit, as this area has, as there have been weeds growing up through the gravel and grass growing up through the gravel in certain areas, so that will need to be rectified in the interim between now and when he gets his permits. With that being said, I'll be happy to answer any questions. Mr. McLeod has been patiently waiting his turn and is here if you have any questions for him.
All right. Thank you, Mr. Blomley. Questions for Mr. Blomley? Mr. McLeod, anything you'd like to add to your application, sir?
Well, only because I brought my son here to see what a government meeting was like, and if I'm not going to get up in front of the podium here, I feel like I should give him that courtesy. I've been doing this little show for 27 years. I was a child when I started, and this will be I'm the new kid in town. We've been doing this in Williamson County for a long time, and we're excited to be in Murfreesboro. So we certainly appreciate you considering our little adventure. And if you have any questions for me, I'd be happy to answer them. If not, I would like to make an analysis of my experience, and that is, in the other planning commission meetings that I've been before, we have fortunately been grandfathered in. Once we get approved with no comments in the years to come, I noticed how my other folks over here have been approved with no negative comments over the past few years. Shorten your work. Approve them in staff, and don't make them go through this process if you want to. I'm sure I'll be here for a few years to get y'all happy with me for a few years, but I'll do my best to run a good job. Thanks.
All right. Thank you. All right. At this time, we'll conduct a public hearing. Anyone present wishing to speak for or against the application? And seeing none, we'll declare the public hearing closed and open the floor for further discussion or motion.
No further discussion, Mr. Chairman. I move for approval, subject to staff comments.
Second.
Motion and a second. Any further discussion? If not, all in favor say aye. Aye. Any opposed? All right, Mr. McLeod, that application has been granted. Appreciate you being here. Again, appreciate your patience. All right, now staff reports and any other business.
I do have something I wanted to hand out to the board.
Surely not. Surely not.
And we do need to read this into the record today.
And I won't put you through that. But this was something that was very interesting to read. I thought that the board members, since this is something that we see on a regular basis, would find this of interest and of use. Yesterday we had our legal teleconference in the legal department about regulating cell towers, and Mr. Adelot asked me to pass this out to you. It's the August edition of a publication that we received called Zoning Practice, and it's got some good information in there for us to consider in the future when we're reviewing cell tower applications. One thing of particular interest is beginning on page 4, it talks about FCC shot clocks. And basically, What that talks about is a ruling by the FCC that says that municipal governments have a certain period of time to act on co-locations and on new cell towers. So it's all good information, and during your vast amounts of free time, if you have an opportunity to read that, I think you'll find it very helpful.
All right. We'll pour over this.
Just not tonight.
I'm confident of it.
Pour something over it.
And another thing that I wanted to mention is just a quick note is that in November and December, we have alternative meeting dates. Normally our meetings are on the fourth Wednesday of the month. In November and December, they're on Mondays because of the holidays. So just one thing to bear in mind. I know we get into a routine, so...
And one other thing, Matthew, and we talked about it a second ago, but that is, if you can have Mr. Lewis maybe refresh us on where we are as far as our continuing hours that we need to pick up.
I'll be glad to, and thank you for the reminder.
Okay. All right. Any other business? We are adjourned.